Welcome to the third hearing for the review of the Heritage Act 1977. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of this land. I would also like to pay respect to the elders, past, present and emerging, of the Eora Nation and extend that respect to other Aboriginals present. Today's hearing is being conducted virtually. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. Today, we will be hearing from a range of stakeholders, including the New South Wales Aboriginal Land Council, the Aboriginal Cultural Heritage Advisory Committee, heritage consultants and practitioners, and owners of items on the State Heritage Register. Before we commence, I would like to make some brief comments about the procedures for today's hearing. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry, terms of reference, and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to? And could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they are not speaking? Please remember to turn your microphones back on when you are getting ready to speak. If you start speaking whilst muted, please start your question or answer again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so we can all be heard clearly. Also, to assist Hansard, may I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. I now welcome our first witnesses, Ms. Meryl Witt and Ms. Alexandria Barnier. Could each witness please state their name and position title and swear either an oath or affirmation, starting with you, please, Ms. Witt.
My name is Meryl Witt. I'm on the leadership group of Better Planning Network. I solemnly, sincerely and truly declare and affirm that evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you, Ms. Witt. Ms. Barnier, could you please state your full name and position title and swear either an oath or affirmation?
I'm Alexandria Barnier. I'm an Associate Director in the Heritage team at Urbis. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms. Barnier. Would you like to both start by making a short statement to the committee? Ms. Witt?
Yes. Thank you again for the opportunity to speak to you today. As I mentioned, I'm on the leadership group of the Better Planning Network, which is an umbrella organisation for local groups across New South Wales. In our submission, we addressed the importance of making heritage conservation an integral part of the Environmental Planning and Assessment Act. In my opening remarks, I would like to highlight some important examples to illustrate why heritage must be front and centre of strategic planning schemes. Last year, the historic homestead of Mount Gilead near Campbelltown was added to the State Heritage Register. The Minister responsible for heritage, the Honourable Don Howan, rightly observed that Mount Gilead is an outstanding early 19th century colonial estate with a spectacular sweeping landscape. I practically grew up next door to Mount Gilead, equally superbly situated property of Meadowvale. It was originally part of a 100-acre land Governor Macquarie made to Andrew Hamilton, the father of the pioneering explorer Hamilton Hume. I often wondered how these two magnificent properties, rich in both colonial and Indigenous history, survived intact for so long. As it turns out, they owe their existence to visionary planning controls that were put in place in the early 70s when Campbelltown was declared a satellite city. Guided by the goal of balancing the new city's growth needs with the conservation of the special assets of the landscape, the rural properties surrounding Campbelltown were originally protected through zoning restrictions on land use, a minimum subdivision rule of 100 hectares, and innovative development controls like the Scenic Hills Protection Zone. When the Mount Gilead homestead was declared a state heritage site, the Environment Minister, the Honourable Matt Keane, said the decision was also a win for the koalas, commenting that it is vital we pull out all the stops to protect koala habitat, but also the structures that help define us, who we are as Australians. According to the Chief Scientist's report, Advice on the Protection of Campbelltown Koala Population, the Mount Gilead estate is home to 3 important koala corridors and provides the koalas with the shortest route between the Georges and the Peenemünde. But the land surrounding the 150-hectare state heritage listed homestead has been rezoned for urban development. The Gilead precinct represents the first stage of Greater MacArthur 40, a strategic planning scheme that will see thousands of hectares of rural land release upwards of 58,000 new homes. The stunning scenic vistas from Gilead, in my humble opinion, some of the best views in all of Australia, will be blighted forever by development. In its submission to the inquiry, the leading law firm Smith Herbert recommended that the committee consider the listing of cultural landscapes with state significance and also identify a best practice approach for cultural landscape protection. In 2012, UNESCO warned the Australian government that the World Heritage listed Old Covers and Parramatta Park were at risk of being declared, in quotes, in danger because of urban encroachment in the peripheral areas, especially all the new, in quote, tall buildings undermining the integrity of the colonial sites. Placing heritage protection on the entire Gilead property and the continuum of notable colonial properties along Appin Road would not only protect a significant cultural landscape, it would also save important koala habitat. In fact, the koala habitat surrounding Campbelltown is worthy of a heritage listing in its own right because the koalas who live here are so unique. They're the last surviving chlamydia-free koala population of any significance in New South Wales, and experts believe their protection for ensuring the survival of the species in our state. By way of example, China's giant panda habitat was World Heritage listed in 2006. Both the giant, I'll just go. I'd just like to close by quickly noting that the best protections of heritage can be undermined when a planning approval process gives too much discretion to decision makers. Recently, the Sydney Eastern City Planning Panel approved a DA for a residential apartment building abutting the heritage conservation area of Transvaal Avenue in Double Bay. Woollahra Council have recommended refusal primarily because the DA dramatically breached controls put in place to protect the avenue's ambience, a picturesque cul-de-sac of single Victorian terraces. Unfortunately, this decision is likely to be indicative of the type of rulings we'll see if the proposed amendments to the Clause 4.6 variation request come into effect. Together with the proposed design and place set, these planning instruments will give authorities the power to determine whether a contravention of well-considered development standards will result in an improved planning outcome, in quotes. To date, in quotes, an improved planning outcome is not defined, but seems to rely on a subjective interpretation of the environmental, social, and economic benefits. I look forward to your questions, and I hope my opening remarks have highlighted the importance of adopting a broad perspective to heritage conservation and also an understanding of what robust controls are needed to protect it. Thank you.
Thank you very much, Ms. Witt. Ms. Barnier, would you similarly like to provide a short opening statement?
Thank you, Chair. I'm not making an opening statement today. URBS's views are set out in our submission, but I thank you for the opportunity to talk with you.
Well, thank you. Thank you very much. I'd like to take this opportunity now to invite members of the opposition if they would like to ask a question. The Honourable Peter Primrose.
Thank you, Chair. My question is to both witnesses, but particularly to Ms. Witt. I note in your submission on page 7, the third dot point under recommendations, state significant developments must not be allowed to turn off the Heritage Act. I was wondering if you could just talk further to that. You did talk to it in part in your opening statement, but I would ask both witnesses if they could comment on that further, please.
Yes, well, I was just actually rereading the Haberfield Association put in a submission to this committee that you would be familiar with, and they spoke about, just the whole of Haberfield is a garden city and it's recognised heritage conservation area, and as you know, there was a lot of angst around the building of the tunnels for West Connects because a lot of those really beautiful Heritage Federation homes were lost in the process. I think really this has to be a consideration before these infrastructure projects are approved. There were suggestions at the time that perhaps those tunnels could have been placed a slightly different angle to avoid so much damage to what is truly one of the best suburbs in Sydney.
Okay. Can I ask Ms. Barnier if she has any comments, please?
Yes, Alexandria Barnier speaking. I can't say that URBS considered the effect of turning off the Heritage Act in the context of SSDs in our submission, but I can say in my experience that certainly the Department of Planning does take the comments of their referral bodies incredibly seriously. And certainly we have been sent back a number of times to undergo rigorous consultation with both the Heritage Council, Heritage New South Wales, and the relevant councils, if not further stakeholders as well. So in my experience, we have not necessarily compromised good heritage outcomes by turning off the Heritage Act in the context of SSDs.
Could you give us an example of that?
May I take it on notice and get back to you with some examples? Thank you.
Please, thank you. I'll hand over to my colleague in case he has any questions then, Mr. Chair.
Thank you, Mr. Primrose. The Honourable Mark Buttigieg.
Thank you, Chair. In the submission from the Better Planning Network, Ms. Witt, you refer to the composition of the Heritage Council New South Wales and how you think that it should be restored to its original configuration from 1977. That is a representative from local government, a representative from the Australian Historical Society, the New South Wales Government Architect, and a representative from a representative union. And then you follow on to say that the government shouldn't be able to appoint 8 out of the 9 current members as it does now. because the implication is that it doesn't operate at arm's length from government. Did you want to just elaborate on why you think that original configuration, that 77 configuration, would serve the Heritage Council better than the current one?
Yes, can I just say that prior to the submissions being put in, the National Trust held a Heritage Forum where they had convened two panels. I think it was so well attended. I think there was probably 300 or 400 people. And this was actually one of the recommendations that came out of that panel. So it's not just something that the Better Planning Network is advocating. I think all of the people there, and it was a real mix of experts, community organizations, just interested people in the community. They feel that the Heritage Council needs to have better teeth. I think one of the examples they also looked at was in Victoria, where the Heritage Council really does operate from arm's length from government, in terms that the Minister of the Day just can't overturn a Heritage Council ruling. But I think, you know, for everyone, including the government, to feel confident about the information, that their advice that they're receiving from the Heritage Council, they need to know that the Heritage Council is treated from a broad mix of the community, that they're hearing a wide diversity of views. And I think if the composition of the Heritage Council was strengthened so that it included a local government member, it included more community representation, it included representation from the unions, who, as we know over time, have been very instrumental in protecting heritage in New South Wales through the green bans. I think that would make it more effective, and it probably also give the community more confidence that in the Heritage Council decisions it makes.
Ms. Barnier, do you have a view on that, on the composition of the council?
Alexandria Barnier speaking. Yes, I do. It is not based on the separation between the government and the Heritage Council necessarily, but certainly Urbis does have a view on the range of expertise that is represented within the council at present. I believe it's Section 8, perhaps, of the, do I have it here? Yes, Section 8 of the Heritage Act right now, which facilitates for a broad range of expertise on the Heritage Council, but we don't necessarily see that in practice. I suppose our main concern is that we see very few dedicated heritage consultants and heritage architects on the Heritage Council and on the approvals committees. We acknowledge that specialist inputs and specialist experts certainly add rigor to assessments. However, you can't necessarily expect someone with a landscape background to be sitting on an approvals committee to assess an application that is a boundary to boundary building within the city. So we do think there is certainly some scope for defining further what the expertise of the council is. And perhaps I'll say now that I do agree with Ms. Witt that there might be some merit also in defining where those representatives come from, what institutions they represent. Yes, that's all I'd like to say on that.
Yes, because these are two themes that seem to be coming through from the submissions. That is that, and Ms. Bunny, you've indicated that it's not such a big problem from your perspective, but certainly one view is that the Heritage Council is not independent enough from the minister. In other words, it's handpicked and subservient. And the second view is that there's a lack of depth of expertise specific to heritage. So thank you for those answers. That's all from me, Chair.
Thank you very much, Mr. Buttigieg. I'll now invite members from the cross branch if they have any questions. Reverend Nile?
Yes, Mr. Chairman. I have a question directed to Ms. Witt. Ms. Witt, you mentioned in your submission that heritage conservation needs to be better resourced. And the discussion papers refer to 3 successful grant schemes: the UK Heritage Enterprise Grant Scheme, the New South Wales Endangered Houses Fund, and thirdly, the Victorian Heritage Scheme. Do you see how any of these incentive programs can be applied to specific projects within your community? And can you recommend any points on how these schemes may be improved?
I might have to take some of that question notice, but in terms of actual general funding for heritage education, I think what came out really clearly in a lot of the submissions I've had the opportunity at was that at the local level, where a lot of the original decisions are made, it's not properly resourced. In some respects, it relies too heavily on heritage consultants who often have, unfortunately, I think, 2 masters, like they're employed by the applicant developer to give a heritage report. And sometimes, just recently, by way of example, you'll be read in the paper this weekend about the Gillings mansion that was demolished, Vaucluse Road. And that, I think, was an example where there actually was quite a good heritage report done that was mislabeled as a demolition report. Perhaps of even a wealthy council like Willara being under-resourced so that report wasn't properly assessed. And then we got into this terrible situation where they tried to slap an interim heritage order on it before it was demolished, and it was all a bit too late. That stunning building has been lost. So I think where I think it's really important is that councils are better resourced, and that so that they can properly assess the reports that they're receiving from heritage consultants, because you know, often they are working for two masters. And we have, you know, that I think that heritage report that was done for Vaucluse, 46 Vaucluse Road, was actually an example of it being very detailed, gave a lot of context around why that building was significant, and then remarkably just said at the end, well, they've made a few extensions back of the building, it doesn't need to be preserved. Where the eastern and northern facade of that building were perfectly intact. And I think if, you know, keen eyes from an experienced heritage officer would have immediately questioned why that final recommendation in that report was made. So that was just a very unfortunate circumstance. And the rest in the schemes, if I could get back to you, that would be great.
Yeah. Mr. Shoebridge.
Thanks, Mr. Chair. Ms. Barnier, you don't support the additional categorisation approach that the government has put forward in its discussion paper. You say that's going to lead to further inconsistency and a more convoluted process, which would be hard to imagine in the heritage space. But can you give us some brief observations about why?
Yes, absolutely. Alexandra Barney speaking. I would like to say to you that it is my clients who often get the most frustration out of trying to navigate our current heritage approvals system. But to be honest, I think certainly myself and I assume many other heritage consultants are now also in the same boat. We find many inconsistencies between the assessments made by each individual agency within those agencies, in terms of assessing very similar applications on very similar properties. To be quite honest, it's usually a case of trying to remember what the previous officer told you a week ago, which was different to what the officer told you 2 weeks before that. I think further categorisation, firstly, I question whether Heritage New South Wales has the resources to undertake such a project, and whether they should be diverting those resources away from assessing the applications and the proposed heritage listings that are currently in the system. And also I question whether they will be able to maintain a sense of standardisation across even more categories. In addition to that, my observation is that, I apologise, I have someone. May I mute for a moment?
Sure, Ms. Barnier. We're all facing these stresses. I might go to Ms. Witt, and then you can come back when you've dealt with your pressing domestic issue.
Sorry, they seem to have left now, if you'd like me to continue.
Yeah, that's okay. You may have noticed the shadows going back and forth in mine. There's, school breaks and cooking. It's happening in all the households.
It's a persistent postman, it seems. Alexandria Barnier, just continuing. The other observation that I would make is that the categories proposed by Heritage New South Wales certainly do seem to speak to a heritage system, heritage approval system and listing system that already exists on a wider scale. They do seem to be potentially overstepping in assuming that they will be assessing the exceptional national values of the Sydney Harbour Bridge. That responsibility sits with the Department of Agriculture, Water and the Environment in Canberra. And they, in my experience, deal with those applications efficiently and successfully. And I don't see the need to further categorise that on a state level.
Ms. Witt, briefly, what's your views on the proposed categorisation?
I guess I just worry that the lower categories could be downgraded in importance. That I guess I would argue that like all heritage is important. By the same token, I think it's really important that we get a lot more heritage onto our lists, and also look at redefining character as well as like in Willaro Council character listing, but it doesn't actually protect the building from demolition. It has to move up the status to heritage. And I just think that that's extremely important, that the definitions but we can save as much as possible. I think the real thrust of our submission and the other submissions I'm reading is that people are really worried about losing local character and for their neighbourhoods. And recently, Elizabeth Farrelly spoke about cities.
Ms. Witt,
Yeah,
I'm sorry.
Sorry. But I think that's what I mean. I think in terms of the categories, it's important as long as the lower ones aren't downgraded.
I just have one final question to put to both of you, maybe starting with you, Ms. Barnier, and then going to you, Ms. Witt. One of the consistent themes in the submission is the fact that the Heritage Council does not have independent resources and independent staff, and is dependent upon the advice coming from the government department, often from agency employees who are working towards different ends on behalf of the government. First of all, two questions. One, do you support the Heritage Council having its own guaranteed independent resources? And secondly, probably first to you, Ms. Barnier, do you think if that was the case, if there was a pool of consistent resources available to the Heritage Council, that may reduce some of those wild fluctuations and randomness in the assessment process?
Alexandria Barnier speaking. Yes, I think there is benefit to the Heritage Council having their own pool of resources. I question whether having their own pool of resources would solve the issue of wild fluctuations in terms of assessments. It is something we very much called for in our submission, and I would like to see that consistency come into effect. But to be quite honest, heritage and design and architecture and significance, they're inherently subjective things. Sorry, is someone else talking? No. I think there needs to be some pretty day-to-day changes that need to happen in terms of the training of any staff, whether it's a dedicated staff or the staff that exists now, to establish some consistency there. I'm not sure these things can be overcome by selecting a particular group of people.
Ms. Witt?
Yes, I heard that came up in the hearing Friday when you were speaking with the minister and his staff about that issue. I hadn't realised that it didn't actually have its own dedicated staff. I think it's absolutely essential, and I think it's also essential for the Independent Planning Commission to have its own staff as well. I think the emphasis with the government is to say, well, we look at the Heritage Council and the Independent Planning Commission as sort of critical thinkers that sort of look to the advice they get from the departments. where in fact I think they should be able to bring in their own experts and have their own staff that can carefully evaluate the submissions they're receiving from government about these issues.
Thank you very much.
Scott.
Thank you, Ms. Witt and Mr. Shoebridge. Government members, any questions? Mr. Martin.
Thank you, Chair. My question is directed for the Better Planning Network. Your submission mentions the importance of consulting with communities, and what are some of the issues that the current consultation process for heritage listings, and how might that be improved?
So Meryl Witt here. I think that what we've seen at the planning panel level is that objections from the community to have been overlooked or not considered. I think that's the point I was trying to make at the end, was a lot of the decision-making powers have been taken away from the local level. And in some respects, you know, that's a more arm's-length approach was needed. But I think the pendulum has swung too far. I think the idea that you can get a petition together and it could have 100 signatures of people to the demolition of a heritage, a site that should be listed as heritage, or a heritage, or amendments to a heritage building is counted as only one unique submission. It just doesn't make any sense. I think everything should be, a lot more needs to be in this space to encourage more community consultation. At the local council, we had a recommendation to bring back, you know, heritage committees that can also inform council's understanding and allow them to nominate heritage listings as well at the local level, and going all the way up. I mean, the problem really is that I know, because I'm also a member of several residents associations, we're just really under-resourced, and we even the Better Planning Network was just struggling to keep up to so many submissions we've had to write recently, and in response to so many changes in the law. So anything that can support community involvement, I think, is critical.
And could I just follow up briefly? What about specifically in relation to heritage lists themselves rather than new developments or things of the sort?
Well, I think, you know, I mean, obviously, the community has an opportunity to comment when planning proposals for heritage listings, for example, go on public exhibition. I just think that it kind of needs to come in earlier. It really needs to be, the community really needs to be actively involved at the council level and also at committee level to the Heritage Council in identifying heritage that should be protected. Because I think there's expertise out in the community that's been a bit left untapped, and lots of opportunities missed. For example, as I referred to before, to identify building places that need to be considered. I mean, I did bring up. Yep, sorry, I won't go on, but
no, it's okay. I'm just conscious of time, and I know my colleagues have questions. Thank you.
Mr. Franklin.
Thanks very much, Chair. And thank you both for being here. Can I just ask a couple of questions to Ms. Barnier? And it's about some of the practical suggestions that you've made in your submission in terms of particularly funding heritage. The first I wanted to talk about was the revolving heritage fund that you referred to in your submission. Can you could you elucidate a little about how that would work and the benefits that would provide for, preserving New South Wales state heritage?
Alexandria Barnier speaking. I regret to say that assertion was largely based on the report that Mary Naggs wrote in her ICOMOS paper in 2015. I'm happy to summarise our key points that we took from that document, but I don't have it in front of me, so may I take that on notice?
Yeah, absolutely. The other one I was going to ask you about was the heritage loan scheme that you talked about as well for adaptive reuse of properties, and was wondering if, in a similar vein, you could talk about that. Basically, obviously, what we're looking for is some really proactive, sensible suggestions that can assist in protecting heritage. And this, I thought, was an excellent one.
Yeah, absolutely. Alexandria Barnier speaking. We absolutely think that a loan system would certainly incentivize and motivate architects and owners to own heritage, to celebrate it, and to really engage with it. The difficulty, I suppose, that you all might have in terms of public policy is finding that money, and I suppose we don't purport to understand where that necessarily would come from. The loan scheme, I imagine, would need to run in tandem with something like the National Heritage Lottery, which exists in the UK, which generates those funds in the first place. Whether we have that opportunity here, I don't know. I suspect not in terms of a national lottery, but certainly there's a further piece of work that would need to be done to understand where those funds would be generated, particularly when considered on balance with all the other suggestions that we've made, that certainly diverts public funds to private owners for the conservation of heritage. So there are some challenges there, and we certainly acknowledge that, and are very happy to be part of future conversations that explore how that could work on a more practical level.
Okay, great. Thank you.
One quick question from the government, Mr. Mallard.
1 minute to go. My question, it's Shane Mallard. My question is to Ms. Barnier. In your submission, you talk about the difficulties with in the process of listing or removing items from the heritage register. So taking things off, putting them on, it can take up to 2 years. You might not have enough time, but do you want to basically enunciate what reforms you would like to see in that process of listing and delisting heritage items?
Alexandria Barnier speaking. Resourcing, I think, is the first issue, and something I'm sure you'll hear over and over again. Certainly, there's been some items that have been sitting on the nominations list for the State Heritage Register for, I think, close to 10 years, in the case of a couple of buildings. I think there also needs to be a more efficient triage process. I believe this is already happening, has certainly been happening for the last couple of years. But again, I've been involved in several projects where we've had items that were nominated by the community and kind of sat on that triage list for up to a year. I think it all comes down to resourcing and potentially being more proactive with proactive heritage studies and having more faith in the process that we have.
You would see a role for the state to be proactive in doing heritage studies.
Sorry, could you repeat that?
Would you see a role for the state to be proactive in heritage studies?
Yes, I do. I think the Heritage Council and Heritage New South Wales could be more proactive in heritage studies, absolutely. And I think that on a state level and a local level would avoid a lot of the reactive nominations that happen at present at both levels.
Yeah.
It would certainly free up some more resources to be considering those items that truly were overlooked for whatever reason, and those items can be considered more efficiently and management put in place.
Okay, thank you. I think we're out of time.
To Ms. Witt and Ms. Barnier, I'll take this opportunity to thank you both for attending this hearing, for your input and participation. The Secretariat will be in contact with you in relation to the questions you have both taken on notice, and they'll be in touch after the transcripts are produced, and you'll have 21 days to respond. We'll take a short break to accommodate the changeover of witnesses. A friendly reminder to committee members to please go on mute and switch your videos off until we come back at 10:45 a.m. Thank you.
Where to turn off. go into mute.
Sure.
I don't know.
Hello, it's the chair speaking, Peter Poulos. To the witnesses who've just joined us, could I just conduct a very quick sound check, starting off with Miss Denny, please?
Hello.
Thank you, Miss Denny. Quick sound check from Miss Vinton, please.
Hi, it's Natalie Beaton.
Perfect, thank you very much. And Dr. North, a quick sound check, please.
Morning, Mac North here.
Thank you.
Yeah, they're at the top.
Good morning and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome our next witnesses, Ms. Kate Denny, Ms. Natalie Vinton and Dr. McLaren North. Welcome. Could each witness please state their name and position title and swear either an oath or affirmation, starting off with Ms. Denny.
Hi, Kate Denny from Lucas Stapleton Johnson. I'm a partner and heritage planner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms. Denny. Ms. Vinton, please.
Hi, my name is Natalie Vinton. I am CEO of Curio Projects. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you, Ms. Vinton. And Dr. North, please.
McLaren North, Managing Director of Extent Heritage. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Dr. North. Would each of you like to commence by making a very short statement, because I'm mindful of time, to the committee? Ms. Denny, would you like to make a short statement?
No, thank you for the opportunity though. Thank you.
Thank you. Ms. Vinton, did you wish to make a short statement?
Yes, I did, if that's okay, and I'll make it very quick. I just wanted to say, most of us here today would have at some point used an historic German proverb, which was first recorded in the 15th century as, "Don't throw the baby out with the bathwater." It's the idiomatic expression for making sure you don't make an unavoidable error in which something good is eliminated when trying to get rid of something bad. Or in other words, rejecting the favourable along with the unfavourable. In this review of the Heritage Act, I request that you remember that the objectives and intentions of the Act itself, the Heritage Act is the baby. It's the good that must be protected. It provides the legal framework for protecting the heritage that the Jack Mundys and Juanita Wilsons fought so bravely to conserve. The strategic framework that is used to manage the Act, the guidelines, the agencies, the policies and everything associated with it are the bathwater that sit around that baby. So as the Act matures, we need to ensure we continue to nurture, protect and grow it to be a responsible, ethical and an inspirational piece of legislation. We need to safeguard it when it needs to be safeguarded, filtered out the toxic processes carefully as required, recycle where possible and introduce no new harm. In conclusion, I'd just like to state that I believe a successful Healthy Heritage Act will promote and deliver inclusive heritage management for Indigenous and non-Indigenous Australians, where both the baby and the bathwater can remain clean and healthy. Thank you for allowing me to speak today.
Thank you, Ms. Vinton. Dr. North, did you wish to make a brief opening statement?
Only insofar as echoing some of Ms. Vinton's sentiments that the issues here before us are, I think, less about the structure of the legislation itself than many of the practices around its administration, and that what we need to keep focused on is the outcomes that we desire from heritage legislation generally. Thank you.
Well, thank you very much for your collective cooperation in shaving some time off from your opening statements. I'll now invite members of the opposition if they have questions. Mr. Buttigieg.
Thank you, Chair. Look, perhaps to you all collectively, feel free to jump in. If it's a common view that the architecture of the legislation is in fact fundamentally sound and it's largely a function of administrative resource failure that we're not getting the outcomes we desire, did you just want to elaborate if there are any areas in the context of the discussion paper that you do feel would be amenable to change in the Act?
McLaren North here. I'm happy to at least start. In terms of excuse me, in terms of actual legislative reform, the processes around listing and delisting from the State Heritage Register which have been subject to change over the last 10 and 15 years, have become, I think, unnecessarily cumbersome. And there are mechanisms that could be streamlined within the Act around the processes of listing to simplify both the addition and the removal of items from the State Heritage Register. I think one of the issues that has been forgotten is the idea behind having a register as opposed to a reactive system of conservation orders was that it was meant to be dynamic, and therefore it was expected to change over time. And that objective has been lost, and partly because the processes around adding and removing items from the register are so challenging and time consuming.
It's Natalie Vinton here. I agree with that sentiment 100%. And I also think that we need to look at how we streamline those processes in order to gather information in a way and use the legislation in a way that's more commensurate with how perhaps First Nations would prefer to manage their heritage. I don't think that the Act allows for that in a particularly dynamic way. For example, what I mean by that is that a lot of the intangible heritage values of First Nations, it's an oral history tradition that is handed down. Yet even to have a site listed in the Heritage Act requires a very strong ability to want to do historical research, written detailed reports, assessing significance about guidelines that were established initially for heritage buildings, really. So it's understanding how in the legislation there may be something in there that allows First Nations to more comfortably and more accurately record heritage significant places, culturally significant places, as part of the Heritage Act protection, if that makes sense.
Thank you, Kate Denny speaking. I have to agree with both the previous speakers, particularly with regards to Aboriginal and Indigenous heritage and how it's currently managed. I think that there's opportunities there for a broadening of the way the assessment processes are undertaken for Aboriginal heritage to be tackled in the legislation. Just as a simple example, to have more work done on cultural management plans as opposed to conservation management plans. I also think that there is opportunities in the legislation for further work to be done, again, to make the system swifter, easier, and more approachable for owners of heritage properties in terms of site-specific exemptions for their individual properties and also heritage agreements. There are two aspects of the Act that I think are not well utilised and certainly not well promoted. I understand that it is probably a bit of a pickle trying to get both of those aspects of the Act put into place. And I think that improvements could very much be made around those two items. Thank you.
Thank you. I might just ask one more before I hand over to my colleague. So in terms of the proposed category system, whereby you would have a hierarchy of categories from state significant items like the Opera House, Harbour Bridge, down to local categories largely administered by local councils. It seems to me, look, some of the evidence we've heard on record to date, the implication is that may be a downgrading of the significance of a local item because it's down the bottom of the category system. And I guess that sort of strikes a bit of an alarm bell with me in terms of if you're wanting to connect the community with heritage value, then one of the ways you would presumably do that is through the connectedness through local councils, because it's the closest form of government to people, and communication lines tend to be more facilitative through those local government areas and councils. Did you have any views about that category system and that potential problem, I guess?
McLaren North here. I'm happy to take that to start. Again, I think that the existing categories themselves probably don't need to change because, again, they align with the levels of government and administration. I suppose the difference that we've seen is with respect to local heritage, because it is allowable to demolish an item of local heritage under the planning legislation, where it is not allowable to demolish an item of state heritage under the Heritage Act. That in practice, there certainly are cases where local heritage is lost because it can be seen as something that can be sacrificed. I don't know that I would go so far as to say that there should be a prohibition on demolishing every local heritage item, because I suspect that that would cause a whole range of other intractable problems. Part of the issue, again, has been the resourcing that local government has put into their local heritage systems. As I alluded to in my submission, there are still many local heritage studies out there which are quite deficient, either in terms of their coverage or in terms of their level of assessment. It is not unusual to find local government heritage studies that were done in the 1980s that have a one-line statement of significance that says, this property is significant for historical reasons. Now, that really doesn't provide any useful guidance. We've been involved in a number of local heritage studies over the last 2 to 3 years, primarily for inner city councils, which have spent a much greater level of resources on actually assessing the items of local significance so that they can be better understood. So in the absence of good information about why something is significant to the local community, I think when you look at it in a planning context, it becomes very difficult for a council officer assessing an application to make a credible distinction between why something is and isn't significant, or it should or shouldn't be changed when there's an information vacuum. And filling that information vacuum is going to be a big part of making that system of local heritage more effective.
It's Natalie Vinton here. I guess I wanted to add to that, and again, I agree with Matt, what Matt has actually stated, and I've had a slightly different approach in that I think sometimes there's too much of a gap between state significant and locally significant. And when I first started in heritage 25 years ago, I think, we used to have regional gradings, which I'm not saying necessarily that's what's required to be brought back, but I think what happens is collectively local heritage, such as if you take an area like Paddington or Haberfield, when you collectively protect your local heritage as a group, it then becomes elevated to a point of having more significance across New South Wales for a start. So sometimes there's an in-between where it's the individuals as a collective make something state significant, but each individual house, say, for example, each terrace itself may not be so spectacular to warrant state listing, but as a whole suburb, you find something lifts to that level, and it's the sum of the parts that make it so significant. But I think what happens is there's nowhere in between that state and that local level. So if you have a state listing, you have such a large raft of legislation and such a large set of criteria to work through, and it may be that your site is state significant because externally it's exceptional or it meets some of the assessing criteria at a state level, but reality is its day-to-day management is by local communities. And I think that's where the pressure point is in that legislation, is there is too much of a jump. So I've recommended in my submission that there should be a bit of a tier that allows the management to suit the actual item, as opposed to just large buildings, estate, or esteemed buildings are state and smaller homes are local. It's about looking at the properties and, as Mac has said, understanding the significance of them and having a bit of a tier in there to allow some more fast tracking and streamlining for everyday sites that are still contributing. Thank you.
Kate Denny speaking. In response to your question, I suppose I just want to raise the flag a bit for the rural and regional areas of New South Wales in terms of their local heritage. I've been involved in a few jobs that have taken me outside of the inner suburbs of Sydney. Not enough, because that is the area that I'm most interested in. And I find that the regional and rural councils are screaming out for assistance, for information, for acknowledgement of their diverse heritage on a local basis, and the information is just not there. Heritage studies are now really quite dated, that, you know, haven't been done about 25 odd years ago, and there's been no subsequent updates. When I've been working, in particular, I worked through the Hunter Valley, and I found that some of the local councils there were really wanting us to acknowledge certain types of historical development. In particular, Gloucester Council area springs to mind. They were really wanting the history of their dairy industry to be acknowledged. Unfortunately, my remit was not that, but it was just it emphasised to me that the rural and regional areas are really wanting help in acknowledging what is really very important to their local communities, and subsequently should be probably acknowledged on a state level as well, once a greater understanding is made. So resourcing towards the rural and regional areas is, I'd be going for that full on. Thank you.
Thank you, Ms. Denny. Mr. Primrose, did you have a very quick question that you could direct to one of the witnesses?
Yes, and I'd like to direct it to all three, but please take it on notice if you would, because I've only got a very short time. And that is, I note, Dr. North, on page 3 of your submission, you specifically address the objects of the Heritage Act, and you make reference to that the objects could be amended to include, and you suggest a number of things. I'm wondering if you could come back to us and just expand on that. I mean, actually list the objects, and maybe, if you would, include some very specific things that you would actually include and what you would exclude from the objects, how you would redraft it. And I'd also invite the other two witnesses, if they wish to maybe also take that on notice. Thank you.
All three witnesses, are you comfortable with that?
Yes, thank you. I'll take it on notice.
Thank you very much.
Yes, happy to take that on notice.
Thank you, Dr. North. I'll now invite our members of the crossbench if they have a question.
Yes, Mr. Chairman.
Thank you, Reverend
Fred Nile. I have a question for Ms. Denny. In your submission, you state that the suggested 4 heritage listing categories as outlined in the discussion paper make no sense. What do you see as the main obstacles of the category system, in addition to what you've already stated? Thank you.
Thank you very much for the question, Kate Denny speaking. Yes, sorry, I was very blunt in my submission, I must say. I suppose my response in my submission to that was that I don't actually understand what is trying to be achieved in the 4 category system of listing. We already have world listing, which protects those very, very important places which people have used as examples already, such as the Opera House, and also, of course, national heritage listing. Then we have state, which is what we're talking about today, and then separately local heritage listing, which is not actually protected under the Heritage Act. It's protected under the EP&A Act. So I struggled to understand what was trying to be achieved with introducing a categorised system of listing, because in my mind, if you're of significance, then you're of significance, and that it's really about how do you manage that significance, how do you manage the conservation and protection of it, and how do you also then support owners to be able to adapt their properties suitably for their own needs and for the community's needs. I hope that answers your question.
Good, thank you. Just one further general question. You probably know this already, that the Art Gallery of New South Wales is not listed in the SRH. What's the reason for that? Have they made an application that's been rejected, or they have not made an application? Shouldn't the Art Gallery of New South Wales be listed?
McLaren North, I'm happy to respond to that. There has been in the past custom and practice of not listing some government assets on the basis that they weren't under threat. I personally don't agree with that. I've worked with a lot of state agencies over my career where we've heritage listed everything from office buildings to schools to water pumping stations to dams to electricity substations, and it hasn't stopped any of them from performing their function. I think the fear of having to be answerable to another party is probably part of the reason that the art gallery itself hasn't been put forward. The fear of unnecessary bureaucratic interference with their operation. Personally, I don't think that fear is warranted, and clearly the art gallery would make sense as an item of state significance. But I think it's hardly the only state asset which is unlisted, which should be.
Kate, Denny, if I may follow on with that, I totally agree with what Dr. North has said, and it actually highlights one of the aspects of the Heritage Act, which perhaps we should have talked about earlier, asking about what legislative changes could be made, and that's about the Section 170 register aspect of the Heritage Act. It's sort of a quasi-state, quasi-local listing for government-owned properties, and they just sort of tend to sit on a great big register. There is obviously asset management requirements that the whatever the public authority is who owns those has to complete and go through, but they can very easily slip through the cracks, and they can also very easily be removed from Section 170 registered and neither become an official state heritage item or a local heritage item. And so I think that there's opportunities for more work to be done around the 170 register and what its function is today, and whether it should actually exist or things should be moved onto the formal registers. Thank you.
Yeah.
Thank you, Ms. Denny. Mr. Shoebridge?
Yeah, look, thank you all for your submissions and your time today. Look, I suppose I should put onto the record that over a decade ago, Ms. Denny, your firm provided some heritage advice for the property I'm in at the moment. I don't think that amounts to a conflict of interest, but I will say you're hard taskmasters. You defend heritage as against even your clients. So I just put that on the record. The Ms. Denny gave her position on the categorisation, the proposed categorisation from the government. But do either of the other witnesses have a view about the proposed additional categorisation?
Natalie Vinton here. I mean, I have to admit, it was a little confusing to me as well, for the same reasons that Ms. Denny noted in terms of what it wanted to achieve. But it did open my mind to thinking about, would categorisation help in the way that it's applied, for example, for English heritage, where you have different tiered properties which allow you to make different levels of adaptation to them. And I think we have those four overarching categories that work well in terms of, yes, local, state, national and world. But I do believe within those categories, there are subcategories which relate to tiers of management. So, for example, recently I was dealing with a property in the inner west, and it's a terrace and it sits within a conservation area, and it's not individually listed as a heritage item. But the feedback initially I became involved after the application was told to be withdrawn, and the feedback you got was that they were making too many changes internally to the house and they needed to change. Now, I took on that job because I thought, well, it's not really fair because they're not individually listed. They're not listed as a contributory item. They're doing everything correct in terms of the principles of the borough charter. And you've got a heritage officer telling them, no, we don't like it because of what you're doing inside your home. Not that they were changing anything to the street. And so I sometimes think it's that lack of informational training for some staff in different areas where if something's in a heritage conservation area and you're conserving its external heritage, then your category or tier of management and the responsibility for council relates to what happens externally, and that's it. And that's where I think things like categorisation would be very healthy and useful and help change some of that fear that sits within heritage management. Is understanding, is your category related to your exterior and your interior, your front yard, your backyard? Well, you know, like those sorts of things that make it easy and defined for both council, property owners and heritage professionals. Which bits should you be worrying about, whether it's at state or local?
Thanks, Ms. Vinton. I will go to you in a second, Mr. North, but I just might follow up quickly with Ms. Vinton. First of all, that would have been with a local council and not under the Heritage Act. That would have been under the council's planning.
Similar happens in the Heritage Act, though, with assessments there.
Yep. And then do you think that could adequately be addressed by more careful prescriptions in the heritage inventory sheets, so you can see very clearly what the heritage values are of a property, and that's an alternate way rather than, you know, splitting up by characterization?
Well, in an ideal world, yes, absolutely. But again, to get those data sheets up to scratch, I guess I'm trying to be pragmatic in that, are you always going to have up-to-date inventory data sheets for every single property listed at a state level or a local level? So what happens when you don't? Is it the onus then on the owner to have to prepare, you know, pay a consultant $5,000 or $6,000 to get it up to scratch? I guess I'm trying to think, what is something that's pragmatic that might be able to be applied in thinking about it? But yeah, the ideal answer is yes, every data sheet would be up to date and it'd be fantastic. And councils will have done the work to make sure the data sheets are at an adequate level.
Yeah, sorry for butting in there, Mr.
McLaren North, happy to add my thoughts. Again, I struggled to see precisely what was trying to be achieved with those categories. I can see some applicability following on from what Ms. Vinton has said earlier about conservation areas and also broader landscape conservation, that these are the things that can fall through the cracks. And when you consider that conservation areas are arbitrary lines on a map and local government boundaries, which are also arbitrary lines on a map, there may well be areas of significance that cross areas of administrative control. I do recall a project that I worked on early in my career, which was around the old Great North Road, which passes through 7, I believe at the time, local government areas. And one of the things we struggled with was, how do you create an administrative framework that works across 7 local government areas to get consistent management? And in the end, it fell into the too hard basket. I mean, there was some discussion about the councils could create a joint local environmental plan, but there was no appetite for that. The other thing I'd say, just following on from your comment about the need for prescriptive measures, I don't know that prescriptive measures necessarily always work. I am aware, for example, of properties in Millers Point where there are very detailed conservation documentation has been prepared, and yet consent authorities are still specifying things like what mortar joints one can put a screw into. Now, frankly, I don't think that's the most productive use of the time of somebody in Heritage New South Wales to be getting down to that micro level of detail, particularly when it doesn't impact on significance. So there needs to be a balance in there. And I guess I think if there's going to be any change to the categorization system, it needs considerably more thought put into it.
We have very limited time. There are two issues I was hoping to cover. One is if you agree what your views are about the three so-called guiding policy themes that the government has put forward in its discussion paper, being making heritage easy, putting heritage to work, and making heritage relevant. Those aren't the themes that have been put forward by the National Trust or the Heritage Council, for example, which talk about conservation and protection. Briefly, do any of you have any observations on that? And we might go to you first, Ms. Denny.
Yes, I think that I probably will err on the side of the National Trust in that the word conservation absolutely needs to be there. I don't disagree that make heritage work can be interpreted in a multitude of ways, including adaptation as well, and which then also links in with make heritage easier. One of your previous speakers today was talking about making things community driven and or customer driven for the Heritage Office, and I must say that I agreed with his remarks. But making heritage relevant, I struggle to understand what that means. Maybe that's just my bias because I'm a heritage planner. It's incredibly relevant to me. But I also think that a broader community would always find heritage to be relevant. Thank you.
Ms. Vinton.
I mean, I echo the same sentiments, but I guess for me, you need to just look at community response to is heritage relevant? And I think when you look at the way communities respond to the loss of significant cultural landscapes or buildings within their community, you can see that it matters. And you can see that I think making it relevant is around it should really be around making it easy to help people with heritage assets, access to information, access to a lower risk management system whereby you're not dependent on individual heritage officers having their own personal opinion around how you develop a site. And I say this because I used to work in the government for a long time doing assessments. And, I could sit next to someone who had a different opinion about how to adaptively reuse a terrace house. But neither of us were required to sort of justify that in terms of, well, this is the council's approach in these types of situations. So it becomes full of risk for people, which is when it becomes negative because people can't guarantee a certain pathway will work because it comes down to personalities within government dealing with personalities outside of government as opposed to a black and white process. So I guess in terms of what I think needs fixing is giving more support and framework and guidance to the staff that need to administer the Heritage Act, and also giving owners of heritage assets more incentives to want to preserve them rather than look to options such as demolition through neglect and those sort of elements. So, and I think I've mentioned, and I won't say much more now because of time, but it's looking at, well, what are the tax incentives for heritage owners? And I think in terms of, is it still relevant? It doesn't matter. You only need to look at cultural tourism, what it brings to New South Wales in a normal environment, which is more than $13.8 billion a year in cultural heritage tourism is generated through the number one activity of visiting cultural heritage sites, whether they be built heritage, Aboriginal and natural. So I think, yes, heritage matters.
Thank you very much, Ms. Vinton. I'll now invite government members if they have a question. Mr. Mallard.
Oh, thank you, Mr. Chair, and thank you to the witnesses for their submissions and their expertise for our inquiry today. It's been very informative. My area of interest, particularly in this, is adaptive reuse. And Ms. Denny, I note that your firm has got a reputation for adaptive reuse and restoration of buildings. I noted earlier witness in their submission said they supported adaptive reuse but not commercialisation. I didn't get a chance to ask where that line is drawn. What I'd like to hear from particularly Ms. Denny, but also the other witnesses, is their views on adaptive reuse of heritage listed buildings, and maybe I wouldn't mind hearing one or two good examples of that. So if you'd like to fill us in on that area.
Thank you very much for the question. Look, I'm a real champion of adaptive reuse. I think it's a really excellent sort of phrase, and but it can be manipulated for and end up with less than great outcomes. Adaptive reuse still needs to put at the forefront conservation and acknowledgement of the significance of a place. But we are talking about heritage places. Obviously, our firm mostly works with buildings, so that's what I'll have to concentrate on. And they are old buildings, obviously, and things operated differently, very differently, 150 odd years ago than they do today. So it is trying to reach a practical balance between the needs of the users and owners and how they want to live their life, work, activate that building, and preserving and conserving the significance, either physical significance or intangible connections that are made with that place. It is a difficult balance. As has already been pointed out, our firm are hard taskmasters, so we do lean on the side of quite traditional approaches to adaptive reuse. That's just our philosophy, and that's not to denigrate anybody else's approach, because there are some excellent examples out there of adaptive reuse using much more contemporary and modern approaches. And I think that there are opportunities for a range of approaches to be demonstrated and celebrated and supported by the heritage. If I may, I'd like to take on notice good examples. I'd like to have a good think about that before I respond, if that's okay.
Yeah, when you referred to the intangible, I mean, an example of that be like a post office that's no longer used as a post office, adaptively reused, but the connection to community as a post office is lost.
Yeah, that's right. And that is a real problem, and you see that everywhere. And that's, you know, where the poor old post offices now just shut over. Yeah, or bank. Banks tend to, in my experience, and I'm, you know, happy to be shot down, that banks tend to be adapted more easily. And I think that's more of an architectural. Post offices were built by the thousands by government architect Vernon, and they're very much more specific in their configuration and appearance than perhaps banks are. They're a bit more modern in their architectural design, and so there's probably easier ways, if I can be simplistic about it, to adapt a bank building than there is a post office, but it shouldn't prohibit that opportunity.
All right, well, thank you for that. Ms. Vinton, would you like to add your perspective to that discussion?
Yes, I mean, I'm also an advocate for adaptive reuse, and from 2004 to 2012, I managed a program for national parks, because I think they're actually the second biggest holder of heritage assets in New South Wales, which most people don't realise.
Okay.
And one of the core aims of that, it was a grants program funded by Treasury, but I changed the program from a maintenance only program to a revitalisation program, simply because maintenance was keeping the buildings shut and it wasn't putting uses into them, because you couldn't get people in to rent them for holiday rentals or use them for other activities, because they didn't have upgraded BCA compliance. They didn't have toilets and bathrooms that you would use that you could rent out. So I spent that 8 years developing a program that would allow national parks to get to the point where they could make the properties continue to be conserved, have their key attributes celebrated, but also adapted enough to allow financial income and return and livability. If heritage isn't living and it's just mothballed, it's not going to be retained for the long term. And that's why I think careful adaptive reuse is so important if it's needed in order to keep a building in use and being viable and at some point offsetting some of its costs. And so that during that period, that's when you saw a big push in getting, you know, the lighthouses turned into accommodation and a whole range of things. And it continues today. But it was changing that philosophy from maintain but don't use through to there needs to be a certain level of adaptive reuse at times. And we're now at a point, just quickly, where a lot of the properties we're working on in the Rocks, we're working really well with designers and architects to get fit outs that come in that are standalone, that look like they're fixed. So it looks like you've got banquet seating and bars and restaurants and things that are all fixed to the original sandstone fabric, but we now have the ability to design and create pods and a whole range of things that you can fit in and fit out. So the technology is getting better for us to do more clever adaptive reuse as well, which is great because it's also cheaper for those putting fit outs in.
Okay, well, thank you for that. I'll do now to my colleague, Ben Franklin.
Mr. Franklin.
Thank you very much, Chair, and thanks, Mr. Mallard. I wanted to pick up, I guess, on the comments made at the end by Ms. Vinton about the importance of cultural tourism. And I note that you talked about that in your submission as well. And I wanted to expand that a little bit more broadly and ask all three of you about, I guess, the importance of heritage in regional areas, which is obviously a specific focus of mine. What can be done and what needs to be done, and if there's anything that needs to be codified extra in order that needs to be done in terms of protecting regional cultural heritage, in contrast to where we tend to focus more and mostly, which tends to be in the urban areas, and B, particularly Ms. Vinton, but if others wanted to link that with a discussion about the cultural tourism and the what needs to be done in terms of increasing that in regional areas as well, I'd be grateful. But perhaps we'll start with Ms. Vinton.
Okay, I'll try and keep this short, or else I'll go on for days about this. But cultural tourism is one of the most amazing benefits for local regional areas and communities because, I mean, lockdown is probably a good example of where Australians have been forced to look at their own backyard and the places they tend to go to, not just coastal towns, but towns that have character, towns that have retained their heritage. And quite often what happens, the towns that have kept their heritage is because economically they couldn't afford to progress and knock down their buildings. So the towns that really prosper are the towns that have their historic character and have been able to gently and adaptively reuse them. So you look at places like Mudgee, Orange, or the little coastal towns, places like Tilborough. And I think what those towns need, and I've said this in my submission, is government needs to get behind them and they need to give them very tailored cultural tourism packages to help them understand what it is they need in terms of, you know, do they need digital tourism maps? Do they need money to get their streets looking just like they need to? And I think back to the Tidy Towns campaign years ago, which really, when you think about that now, that was really about actually fixing up your town to look beautiful. So it's similar in terms of cultural heritage tourism in getting Destination New South Wales behind these towns. What I was doing at National Parks was looking at the benefits socially and economically. If national parks were better maintained near towns, then you have people needing more accommodation, staying in towns for longer, because people who participate in cultural tourism like to eat and drink and buy nice things. When you really break it down, they contribute more broadly to regional areas when there are opportunities for them to stay there for a few more days. So it's about targeting and supporting those towns to see their potential. And I'll just finish quickly. If you look at what's happened to forestry towns and mining towns in Tasmania that have reinvented themselves for mountain bike riding, and the impact that's had, cultural heritage tourism, it's the same types of people. So it's really working with smart Destination New South Wales people, not just heritage experts, but cultural tourism experts to help these towns. And I think it's a state government initiative. It needs to come down from there to really help guide that process and just continue to help those towns flourish.
That's great, Ms. Vinton. Thank you. Does Ms. Denny or Dr. North have any comments to make either on that area or the broader area about the challenges of protecting and preserving regional heritage?
Yeah, I'm actually speaking to you from regional New South Wales today. I'm in the Hartley Valley, just west of the Blue Mountains. I also sit on the Community Management Committee of the Hartley Historic Village, which I'm sure Ms. Vinton remembers well from her time at National Parks. And prior to the regional lockdown, I was able to actually get out and visit some of these communities I hadn't had a chance to visit in a while, a couple of weeks ago. And you look at communities like Orange and Mudgee, they're very prosperous, they're surviving fine. We also drove back through Rylstone and Kandos, which were ghost towns. Lovely little towns, but very little happening in them. And so I think that some of this is how you connect those regional towns into a network. So it's all well and good to go to Mudgee, but why should I go from Mudgee to Rylstone, for example? And frankly, right now, there's probably not a reason. But that's the trick, is to find out how to get these towns working as a network together so that they feed off each other and they're drawing larger crowds for longer periods of time. But I might just speak about Lithgow, which is the closest community to me. Lithgow, former mining town, limited industry now, but it has been. I've lived in the valley for about 9 years now, and I've watched Lithgow reinventing itself as an artistic community. Has active festivals. Events like Iron Fest, which started out as a celebration of iron and steel, draw 20,000 people. Unfortunately, it hasn't happened for the last 2 years, and it's a one-off event. So it's still not quite got critical mass. But again, I think if there was coordination with assistance from the state government between other communities, it would help draw people into the regions.
Thank you.
Kate Denny, I'd just like to add a little bit more to that. One of the great things about regional rural areas is that they all have very distinct characters and histories. And in terms of linking areas together, I think, heritage as its starting point is about history of a place or a building or a landscape. And from there, you branch out into all sorts of other aspects. I've been working most recently in Leeton and part of the Murrumbidgee irrigation scheme, and that's a town that was designed by Walter Burley Griffin, as well as a number of other towns in that same area. Now, there's a whole bunch of themes right there that unify that whole area that could be promoted, and I'm sure I'm not the only heritage nerd in New South Wales that'd be keen to get out there. Well, we've also been working on the Leeton the Roxy Theatre. There are so many theatres and cinemas that are dotted all the way through New South Wales that are, just abandoned or, underutilised. But there's another theme that could really be used to entice people out into, beyond the Great Western Divide.
That's terrific. Thanks, Ms. Denny.
Thank you. It's the Chair speaking, and I'll take this opportunity now to collectively thank our witnesses, Ms. Denny, Ms. Vinton, and Dr. North, for attending this hearing this morning and for your participation. The committee has resolved that answers to questions taken on notice be returned within 21 days. The Secretariat will contact you in relation to the questions that you have taken on notice. So thank you once again. We will now be taking a short break to help facilitate the changeover of witnesses. We'll be breaking until 11:45 a.m. A friendly reminder once again to the committee members to please place yourselves on mute and turn your video off until that time, and we'll be back at 11:45 a.m.
Thank you very much.
Thank you very much for your time today.
Yes, thank you.
To be on mute.
You're in mute.
Be on mute and
G'day, Mark. G'day, Peter.
So much happening.
Hey,
Peter.
Walt. How are
G'day,
you?
Peter. G'day, everyone. I'll go on mute now.
Walt,
So Fred and I was here.
Yes, Mark.
just so you know, Shane and I have to go to a WITS meeting at 12, so I'll just I'll let you and Pete handle it for the next 15, and then I'll be back after lunch.
Okay. I get a few
I have to
questions.
go to which meeting as well, Fred and I.
Okay, I'll take Fred's questions.
Take mine too, Walt.
Okay.
Now it's the chair speaking. A couple of witnesses have just joined us, so I'll just conduct a very quick sound check, if that's okay. Councillor Ann Dennis, it's Peter Poulos. Could I invite you to conduct a very quick sound check, please?
Good morning and thank you.
Perfect.
Hello. Yep.
Very good.
Thank you.
Ms. Holt, quick sound check from you.
Yes, thank you.
Perfect. And Ms. Chalker, could we have a quick sound check?
Chantel, you got to mute.
Ms. Chalker, you might be on mute. Could we have a quick sound check? If you can hear me, Ms. Chalker, if you could take yourself on mute, we could conduct a very quick sound check.
Yep. Can you hear me now?
Fantastic. Thank you so much.
Thank you.
Well, good morning once again, and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome our next witnesses, Councillor Ann Dennis, Ms. Glenda Chalker, and Ms. Mishka Holt. Welcome. Could each witness please state their name and position title and swear either an oath or affirmation, starting with Councillor Dennis.
Thank you. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Councillor Dennis. Ms. Chalker.
Glenda Chalker, Chair of the Aboriginal Cultural Heritage Advisory Committee. I solemnly and sincerely and truly declare and affirm the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Chalker. And Ms. Holt, if you don't mind.
Thank you. My name is Mishka Holt. I'm the Principal Solicitor of NTS Corp Limited. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Holt. And would each of you like to commence by making a very short statement to the committee? Councillor Dennis.
Thank you, Chair, Deputy Chair, and committee members for your time and opportunity to speak today. My name is Ann Dennis. I'm the Chairperson of the New South Wales Aboriginal Land Council and Councillor for the Northwest Region. I'd like to acknowledge country and pay my respects to the ancestors, traditional owners, and elders of the lands from which we are all participating in this meeting from today. The New South Wales Aboriginal Land Council is the peak body representing Aboriginal peoples across New South Wales. We have over 23,000 members, making us the largest Aboriginal member-based organisation in Australia. Really, the current laws relating to the protection and promotion of Aboriginal culture and heritage are outdated and ineffective. We need new, dedicated laws to protect and promote Aboriginal culture. These laws must be based on self-determination and the need to be owned and controlled by Aboriginal people. We don't support incorporating Aboriginal culture and heritage protections into the Heritage Act 1997. The Heritage Act does not meet Aboriginal community aspirations for protection of and decision makings about Aboriginal culture and heritage. New South Wales Aboriginal Land Council advocates that Aboriginal people must be empowered to make decisions about Aboriginal culture and heritage, both in relation to specific proposals and their potential impact and in the running of the system itself. It is also important that any revised Heritage Act improves interactions with planning laws and new ACH laws, resourcing Aboriginal land councils and Aboriginal communities to protect Aboriginal culture for further generation provides a key opportunity to strengthen culture and local communities. This will benefit and enrich and the cultural landscape for all people of New South Wales, and it is important that the government work in partnership with us to progress these reforms. Thank you.
Thank you very much. Ms. Chalker, did you wish to provide a brief statement?
Yes, please. Glenda Chalker, Chair of ATCHAC, Ngadi Bobagal, which means good morning, everyone. And thank you for the opportunity to meet the review committee today. I would like to acknowledge my Dharawal ancestors, past and present, of the country I was born to and where I have lived all my life. I am here as Chair of ATCHAC, which is the statutory advisory body to the New South Wales Government on Aboriginal cultural heritage. Our submission to the review offers 4 fairly straightforward recommendations for what we see as necessary and overdue amendment of the Heritage Act. I am sure the committee has seen those recommendations and I won't go through them again now. I would also like to provide the committee with a copy of the Dharawal vision statement, which was issued last year by the Heritage Chairs of Australia and New Zealand. The statement gives a set of basic best practices standards for any policy or legislation that affects Aboriginal cultural heritage. And it's my understanding that has been warmly welcomed by the heritage ministers across all Australia and New Zealand. May I have that policy document sent to the committee? I will do so. As a general statement on the current heritage legislation, I would like to say that the Heritage Act in its current form does not do a good job of respecting and protecting Aboriginal cultural heritage. The Act does not reflect, as it should do, that all heritage in New South Wales is built on Aboriginal cultural heritage and that every heritage site in New South Wales, including those of state significance, has a primary association over tens of thousands of years with the cultural heritage of Aboriginal people. Of the 1,700 items listed on the State Heritage Register, only 32 are acknowledged as having primary Aboriginal cultural heritage values. These primary sites are regulated under an Act that makes no provision at all for Aboriginal decision making. In our view, that needs to change. I would add that the great hope of ATCHAC and Aboriginal people and communities generally is that there will soon be a wider reform of New South Wales legislation governing Aboriginal cultural heritage. These reforms will see Aboriginal cultural heritage taken out of the National Parks and Wildlife Act and protected under standalone legislation that ensures that decisions on ACH are made by culturally authorised people at the state and local level. Thank you, Chair, for the opportunity to speak today.
Thank you very much, Ms. Chalker. And going forward, just a small favour, because I understand you're having some technical issues. Because your video switched off, do you mind, whenever you intend to answer a question, to identify yourself for the benefit of Hansard, if that's okay? Thank you. Ms. Holt, did you wish to provide a brief statement?
Yes, thank you. Firstly, on behalf of NTS Corp, I'd like to acknowledge and pay my respects to the Gadigal people, the traditional owners on the country on which I appear today, and the respective communities where all of the members present and the witnesses today appear by video conference. I'd like to acknowledge the Chair and Deputy Chair and committee members of the Standing Committee, and I acknowledge Chairperson Dennis and Chairperson Chalker. I also acknowledge the Chairperson and Board of NTS Corp and our CEO. NTS Corp is a company comprised of Aboriginal members from throughout New South Wales, and NTS Corp is the native title service provider for New South Wales and the ACT. We're funded to represent the interests of Aboriginal traditional owners who hold or may hold native title in the lands, seas and waters of New South Wales, and specifically to assist Aboriginal traditional owners to exercise their rights under the Native Title Act. We welcome the opportunity to appear before the committee today to discuss the review of the Heritage Act and Aboriginal culture and heritage reform more broadly. From NTS Corp's perspective, it's of central importance to develop a model for reform which will see Aboriginal sites protected for future generations and which honours the elders and ancestors who've gone before us in their struggle to protect country. The rights and interests recognised by the Federal Court in native title determinations include the rights to maintain and to protect from physical harm sites and places of importance under traditional law and custom. In NTS Corp's view, any new culture and heritage legislation must have culture at its core and respect the traditional systems in operation for millennia, a system in which traditional owners speak for country and make decisions about what occurs there. NTS Corp considers that any cultural heritage legislation in New South Wales must reflect those traditional beliefs and culture. We support standalone legislation in New South Wales for Aboriginal culture and heritage management and protection. We support Aboriginal ownership of Aboriginal culture and heritage. We support greater heritage management oversight, compliance, enforcement and opportunities for self-determination, capacity building and employment, including the right to veto. Broader recognition and definitions of Aboriginal culture and heritage, including intangible heritage, and a broader recognition of the landscape, which includes seas and waters, is paramount. The inclusion of state significant infrastructure and major development in the protection regime is sorely missing at present and is something NTS Corp calls to be included in any reform process. It's a system that needs to be properly funded and set up for success. Establishment of the Aboriginal Culture and Heritage Authority, which is independent of government, is supported by NTS Corp, and localised management of Aboriginal culture and heritage through local panels that have cultural legitimacy, including where native title is determined, that native title prescribed body corporates will nominate the local consultation panel for the whole of the determination area. Where no native title is determined, we support local panels comprising local cultural heritage knowledge holders, being the right people for country. We can't support any system that operates to diminish traditional owners' current or prospective legal rights. We acknowledge the recommendations made in the ACTCHAC submissions, and we consider that they are all sensible amendments to be made to the Heritage Act. And I note for the record that they include objectives that better acknowledge Aboriginal culture and heritage as the source from which all other heritage has derived, the representation of male and female Aboriginal members on the Heritage Council.
Some questions.
And that the Act should be reformed in line with any ultimate Aboriginal culture and heritage legislative reform to ensure that it is consistent. Thank you.
Thank you very much, Ms. Holt. I'll now invite members of the opposition to raise questions, and I acknowledge that the Honourable Walt Secord has joined the hearing for this session, and he has a question.
Thank you, Mr. Chair. For the benefit of Hansard, Walt Secord speaking, and my question is to Ms. Chalker. In your introductory remarks, you said that there were only 32 Aboriginal primary heritage sites out of 1,700. Just to give a bit of a perspective, what are some of those 32 that you were referring to?
Glenda Chalker speaking. The Calgar cultural landscape is one of them that comes to my immediate mind.
Okay. Now, to increase that number, I mean, you obviously would like to see an increase of that number. How would you like to see an increasing of that number occur? And how would you like to see that occur?
Glenda Chalker speaking. Recently, there has been a change of communication between the Heritage Council and ATCHAC. We are actually consulted now as part of the process of any nominations that come forward for SHR list.
Oh, I think she's muted herself.
No.
Oh.
No, I don't have any video though. For some reason.
Keep going, Ms. Chalker.
Yeah, the Heritage Council now consults with ATCHAC on any nominations that come before it that might have Aboriginal heritage values. So
Now,
that is all increasing the numbers.
Now, to increase the numbers, who can actually initiate a nomination that would be in the area that would be primarily of Aboriginal historical significance?
Glenda Chalker. Initially, it's someone within the community that does it, but recently, ATCHAC itself has put forward a nomination for the Appin Massacre cultural landscape to the Heritage Council.
Okay.
Which is the first time.
Right. Now, are you familiar with the state government's Blue Plaques program?
Glenda Chalker, just vaguely. We have a meeting tomorrow, an ATCHAC meeting, where it's being presented to us.
Okay, so this question could be answered by you or the two other participants. Do you think that there would be scope for recognizing massacres and frontier wars through the Blue Plaques program?
Glenn speaking, I think some of the, probably all of the massacre sites and conflict sites all need more recognition than a blue plaque.
Yes. Okay, at the moment, significant massacre sites, how does one know that a massacre occurred at one of those sites? Is there anything at the moment to mark those sites?
Does anyone else want to speak here? There are some that have been identified, and the Mile Creek massacre site is one of them. There are others that are identified through SHR listings and Aboriginal places, possibly. My local one to me is the Appin Massacre site. We have a plaque not on the site because it's private property, but nearby at the Cataract Dam.
Okay, thank you, Ms. Chalker. Question to Ms. Dennis. In your opening remarks, you referred to the current laws being outdated and ineffective. Now, I understand that New South Wales is the only state without a standalone Aboriginal cultural heritage legislative framework. Are there any jurisdictions in Australia that you hold up in the area of recognizing Aboriginal cultural heritage?
Really, the culture and heritage protection lot sits within the National Parks and Wildlife Act, and one of the first when the New South Wales Aboriginal Land Rights Act was enacted in 1983, the government at that point in time said that the next legislation that they would enact would be to better protections around Aboriginal culture and heritage. And really, so it's been outdated, and government hasn't followed through with those protections. And really, when we have like 250 nations of Aboriginal people across Australia, 37 different Aboriginal nation language groups across New South Wales, and the dialects of Aboriginal people in New South Wales alone, the only people that can speak for country and better protect culture and heritage sites on country is the Aboriginal people on that country. And the New South Wales Aboriginal Land Rights Act is standalone legislation, and there are 120 local Aboriginal land councils on country with, as I said, a membership of 23,000 people. And what we've actually agreed on is around where the current legislation is outdated. Really, we've got to be able, the legislation has got to be able to strengthen self-determination and empower Aboriginal people. It must be led by Aboriginal people on country to speak for that country. It must be inclusive and respectful of culture and native title rights. It must build on structures within the land rights and native title network. It must be independent of government, and improve better Aboriginal culture and heritage protection, promote and repair, including the rights to say no. We must have free, prior and informed consent, including the approaches to protection, regulation around intangible Aboriginal culture and heritage knowledge, languages, cultural access and the use to repatriation and water. So, and really it shouldn't be detrimental to land rights. So that's where it is outdated.
Ms. Dennis, you in your previous answer that you just given, you said that you'd like to have options where they can say no.
Yes.
What would be a circumstance? Can you give me an example of where you would like to veto or say no involving? Give me an example.
So I live out at Walgett, northwest New South Wales. I'm the councillor for the northwest. Like 135 kilometres west of Walgett are the Brewarrina fish traps.
Yes.
All right, they are listed as heritage, but Aboriginal people have practically no say in how they are modified and developed, and funding actually comes into the community. And
no say whatsoever.
No, and there is continual subtle changes to the Brewarrina fish traps, and they are 45,000 years old. We can take the incident that happened at Jorkin Gorge in the Pilbara, where it was just blown up. So will the Brewarrina fish traps will be protected in future? Really, it's the Ngimba people of Brewarrina that must have that consultation, and they can speak for country. We as Aboriginal people know who can speak for country, and I know the people who in my community who has that knowledge of those cultural that cultural knowledge. And again, on country, we can put in place those better protections. So that's what, the principles that ACHAC and NTS Corp, really, we agree on the principles that it must strengthen self-determination of Aboriginal people, and it must empower Aboriginal people. And we have structures to be able to put that in place.
Now, with your answer on the Brewarrina fish traps, you've actually sparked my interest in the repatriation and the return of the remains of Mungo men in Western New South Wales. Do you have a view on that? And were local community consulted on whether the remains would be returned, and would they be marked?
Look, I'd have to take on notice about Mungo men and how Aboriginal people were consulted around that. I can only speak for the country where I am, and there are many burial grounds like Angledool, which is like 130 kilometres north of Walgett. So you've got Lightning Ridge and Angledool, where the burial sites are disturbed, and really, us as Aboriginal people, like the Lightning Ridge Aboriginal Land Council, we can't do anything about that unless there is government funding, or we rely on government funding. I look at the sand eels at Gingy Reserve out at Gingy Mission, and the destruction of illegal dumping of asbestos that takes place on our identified reserves, and and it's that respect. And Aboriginal people, we must be the ones who determine how we actually protect sites, and it's not complex for us as Aboriginal people, because language and culture is connected to the land where we live.
I'm sorry, the two sites that you've referred to that were disturbed, the Aboriginal the asbestos dumping. Can you tell me about the previous one? What were the concerns about that site?
Really, again, it's an Aboriginal reserve, so the Aboriginal reserves are listed as as sites on the Heritage Act, but again, they're only listed for mention. There is no protection around the culture and the existing sites that are there. So most sites across our lands are open to vandalism, and how do we actually protect those sites without, we can report to OEH, or we can make those reports, but because of isolation and remoteness, most of those go unnoticed. Usually it's a square development, because usually sites can be disturbed, particularly with state wide developments, and usually that sparks then some debate around what happens. But when it's remote, and the clearing of land, the cutting down of scarred trees, the removal of that without any consultation and protection, that's why we say we must have better protections, better laws, and Aboriginal people, we must have the voice to be able to say no, and we need to be able to protect that site.
Thank you. May I ask, is that the end of my time? Oh, sorry.
It is. Well, if you had a follow on that.
No,
yeah.
I have other questions. I apologize, David.
Oh, thanks, thanks, Ms. Dennis, and to the other witnesses for coming, and thanks for the work you do in between these hearings. It's essential work. Councillor Dennis, could I ask you first of all about what your view, or what your organisation's view, Newswalk's view, is of the way in which once a project is listed as state significant, all of the Aboriginal heritage protection laws are turned off, and probably if you could focus on, particularly in the mining sector, and the impact that has through approvals in the mining sector.
Again, I suppose it's a consultation with local Aboriginal people, and I suppose it's because of it's unclear about is it the Heritage Act, or is it the National Parks and Wildlife Act? Is it actually local Aboriginal Land Council? Is it native title groups? That division, and because government has really failed to deliver on the standalone legislations to protect really companies such as the mining company are really looking at, well, who do they actually talk to? And it's the person with the loudest voice. So it can be quite convoluted, and it can be quite vague at who they actually talk to and who they get permission. There needs to be clear processes put in place, so that and I understand that around Karuna, Walhallow, where local Aboriginal people joined to protect some cultural sites around grinding grooves for and rock formation for Aboriginal people, and there was a place where they actually gone through that process to be able to protect that. And that's why, you know, we agree that, you know, there should be a land council or Aboriginal people of that country should be able to veto, particularly to protect significant Aboriginal sites. So really the laws and legislations are quite they overlap, and it's treated like you have to work in a silo. Well, oh no, we can't look at that. We need to work down this road. So whether it comes under the various local government acts or different legislation that we have to work. Oh, the Heritage Act. Well, it's not listed as an heritage. It's not a building. It's not, you know, it's not respected and valued. So again, it can be quite and it's such a lengthy process. It's, you know, it can be such a lengthy process, and then that can create a lot of division within communities. And that's why we're saying to government, and that's why we're asking you as a committee to ensure that you know, like, it's not just now transferred across, or the Heritage Act is transferred, that we must have better protections for Aboriginal culture and heritage.
Thanks, Councillor Dennis. Ms. Chalker, do you have a view about the way in which the planning system turns off all of the Aboriginal heritage protections, as meagre as they are under the National Parks and Wildlife Act, once a project is declared state significant?
Glenda Chalker. I worked in heritage on the ground for 30 years now. Sorry. A state significant project turns off the National Parks and Wildlife Act. It turns also off the Heritage Act, and it's all done through planning. The only thing that we might get a say in is the New South Wales Heritage can give advice, but there are no decisions made by Aboriginal people on how a state significant project progresses, basically.
And Ms. Chalker or Ms. Dennis, and maybe I'd invite you to respond in that order, starting with you, Ms. Chalker, then Ms. Dennis. One of the areas that's a concern at the moment is in the Hunter Valley. The Wanneroo people are trying to protect their massacre sites, well, sites where tragic massacres were inflicted against the Wanneroo people, from a mining project from mining giant Glencore. Now, all of the state heritage protection laws have been turned off. They're having to rely upon federal Aboriginal heritage protection laws. Do you have a view about that, Ms. Chalker, then Ms. Dennis?
Glenda Chalker. Yes, I do, because that proposal for the mining company is not only about the historic house, it's about the massacre site and all the other sites that are around it that are in line for what I call massive destruction. And the Hunter Valley is only one example of that. We see that in the Sydney Basin every day because of the massive destruction caused by urbanisation, which actually just crawls out a little bit further every day. And most of them are state significant projects also.
Yep, and Dennis speaking again. You know, what's happening with the Wanneroo people is happening right across New South Wales, if not right across Australia, and laws relating to the ACH protections and promotions really, you know, like, they're not designed to give Aboriginal people the community controlled around being able to protect what is left, and you know, just strengthening heritage or you know, the national parks and wildlife really is not going to protect Aboriginal significant sites, and really, I suppose, you know, the New South Wales government, and you know, and they did sign up to the Close the Gap national agreement. You know, they say all the right things, but again, you know, those protections are not there for local Aboriginal people or organisations to be able to work their way through. So again, we're asking that, you know, government must be able to work with us, develop broader reforms, and really uphold the rights around self-determination and free, prior and informed consent, and without them working with the people on the ground, because it's, you know, like as I said, the nations that we, you know, I'm a Kamilaroi woman. I've got Ngiyambaa down to the west of me. I've got the Uluru people to the north of me. I've got the Wiradjuri to the south. I've got Wailawan people, and we are the people that will speak for our country and protect and know what exists and what's there now, and you know, these laws must work with us as Aboriginal people and must give us that right.
And Ms. Councillor Dennis, I know you mentioned the Brewarrina fish traps, and that's a classic case in point where critical decisions have been made by largely, well, non-Aboriginal bureaucrats, which have had major impact on what may well be one of, if not the oldest existing human-made artifact on the planet. The two things that come to mind are the construction of that concrete weir some decades ago, and the damage that did to the fish traps, and then more recently the fish ladder that was put in, and I know was highly contested from elements of the Numba community, saying that it wasn't consistent with their thought about protection. That's a case in point, isn't it, where we should be looking to the traditional owners on the ground to be the decision makers.
Yeah, you know, well and truly, as I say, and that's a classic example. But when you look north of Brewarrina, and you got the Murawari people and the Kalgoa National Park, and you know, the community of Wilmaringal, and they have not got a voice, you know, and when rivers are dry and the protection of site, you know, and usually there's so many other issues, like we've got, you know, we're doing this right in the middle of COVID-19, and you know, and these communities can't even access essential items. They've got no shop in their community, and you know, and really, you know, the destruction or these subtle, you know, this work continues regardless of what else is happening in that community. So that's why it's important that we must talk with Aboriginal people on country.
Could I just, my time's very close to concluded, but could I ask each of the witnesses, what's your view about the priority of the government here? We are progressing changes to the 1977 Heritage Act and prioritising those legislative changes and not progressing through any similar process empowerment of First Nations peoples and standalone Aboriginal heritage law reform. The government has said that they've got a separate process there working with stakeholders. Do you accept the priorities are right? Maybe I'll go first to you, Councillor Dennis.
Look, the priorities are not right, because government will set up different structures and different decision groups, and you know, like if we look at, you know, the New South Wales Aboriginal Land Council and the legislation enacted by Parliament since 1983, and yet, you know, Aboriginal Affairs would set up local decision making models, and you know, and they would promote then regional alliances rather than work with established organisations that's been in our communities for a very long time in getting people to work together. And then we've got native title, and you know, under Commonwealth law, and we're all Aboriginal people on country. So really, again, the processes that the government is actually using at the moment does not strengthen, you know, self-determination and empower Aboriginal people. It's not led by Aboriginal people, and really, you know, as I say, there's about 37 nations and language groups across New South Wales, and all of our groups, we will speak for country, and we know people who are on country, whether we're native title or whether we're a member of a land council, we can speak for country.
Oh no.
I think Miss Dennis.
Oh, sorry.
place
And
herself.
sorry, yeah. So really, you know, it's about us using our processes that we've developed over 40 years to be able to make those decisions. And all we ask is that government work with us to be able to do that. Thank you.
It's the chair speaking. Mr. Martin, have you raised a point of order? I've just noticed.
No, sorry, I just want to speak next, which is probably good timing.
I'll just, on that basis, I'll just revert now to the government members and Mr. Martin.
Chair, could I just invite Ms. Chalker to take that on notice, if she's able to answer that question?
Mr. Shoebridge, that was to Ms. Chalker, is that right?
I asked the question to both witnesses, and I know that time is limited, and I don't want to jump over all the government's time. But if Ms. Chalker can take it on notice. So,
Ms. Chalker, you're comfortable taking that question from Mr. Shoebridge on notice?
Chalker, yes. Can I have the question sent to me again, please, just to remind me?
It'll be relayed in due course, and I'll confirm those details at the end of this session.
All right, thank you.
And I'll just go now to the government member, the Honourable Taylor Martin, with a question.
Thank you, Chair. And I thought it might be good timing because Ms. Dennis was just starting to get to a point in her answer about talking to the engagement so far with the government. If I could ask independently, maybe we'll start with Ms. Dennis, seeing she was at that part of her answer. If I could ask for each of you for a bit of a view on the engagement you've had so far with the government, specifically with the Minister or his office directly, in regards to the proposals for Aboriginal cultural heritage management going forward.
Look, through the New South Wales Aboriginal Land Council, we work extensively with the government around the 2018 bill on culture and heritage legislation, and you know where it's and you know our three groups, NTS Corp, ACHAC and the New South Wales Aboriginal Land Council, we agreed on the 7 principles. And really, I suppose the approach that the government is using is it's not recognising that we are different Aboriginal people right across New South Wales, that we are different language groups and we've got different protocols within our communities and recognising those differences. And really, I suppose the approach to it, you know, for what I see as a chairperson, is it's really a divisive approach in talking to the different groups and different groups at the table, rather than respecting Aboriginal people and strengthening and trying to strengthen that self-determination. It's that divisive group of, well, you know, everybody has to agree. We all have to agree. And, you know, like I say, you know, I can't get my family to agree on most things. So how are we going to get everybody to agree? We agree on the principles around strengthening self-determination, and we must have better protections, and it's got to be led by Aboriginal people. But again, you know, the government in making a decision and that standalone legislation that we've fought for a very long time, again, you know, it's divisive and just keep Aboriginal people separated. And when they ask, I think it's really unfair that they ask that we as Aboriginal people have to agree on before something will happen.
Ms. Chalker?
Glenda Chalker. In the beginning, NTS Corp, ACHAC and New South Wales Land Council all basically agreed on the principles of the 2018 draft legislation. We've been told by the government that it does not support the establishment of the ACH Authority, which is an statutory authority led by Aboriginal Board, which was in the 2018 bill. Over the last year, we've spent some time looking at what sort of statewide body would replace the ACH Authority, and this is still ongoing. The government has also told us that the 2018 bill was too expensive and too complex. So we've been asked to help with co-designing a cheaper and simpler set of ACH reforms. For Aboriginal groups who want the best for Aboriginal cultural heritage, these are challenging starting points for co-design with the government. I use a quote quite often everywhere in my life: cheap is not always the best. You get what you pay for. And if the cultural heritage reforms are too cheap, we won't get what we want and need out of this process. This new legislation should be about what the Aboriginal people of New South Wales want, which was very clear from the consultation in 2018. It should not be about just what the government wants. Self-determination and decision-making by the Aboriginal people of New South Wales is high priority in regards to Aboriginal cultural heritage. Thank you.
I'm sorry, did you want me to also answer that question for NTS Corp? Yes, I'm not sure if you can hear me. Yes, okay.
I can hear Mishka. I think the chair's muted though at the moment.
Okay. Look, I'd just say very briefly on behalf of NTS Corp that the Minister has been particularly engaged in this reform process and has obviously made it clear that he is keen for a reform bill to be developed. But I would say NTS Corp's view is that there are parameters which have been put to the parties which create a series of difficulties. So each of us are charged with the responsibility of conveying the views of Aboriginal people, and the views of Aboriginal people have been clear that they want legislation that will protect culture and heritage and give Aboriginal people a right to speak and make decisions about culture and heritage. Legislation that is modern and reflects the times that we are in, and particularly the New South Wales Government's commitment to closing the gap, which captures increased legal rights for Aboriginal people, increased rights for decision making and partnerships. So I guess one, I think, critical issue from NTS Corp's perspective is the funding for standalone legislation and for the standalone Culture and Heritage Authority. And I think that largely, if there was a commitment to funding that would enable the kind of system to be built that Aboriginal people want, that things would move in a much faster fashion. So it's perhaps the parameters that are placing limitations and that are dragging the process out longer. It has been a process well before my time, back in the 70s, a commitment to culture and heritage reform and protection. And then there's been a series of reports. I'm reminded in 2010, the then Minister Sartor indicated in his second reading speech for the amendment, the National Parks and Wildlife Amendment Bill, that it would be a 2-year period before standalone legislation was developed. So I think that the parties would all be aided by a commitment to the funding to have standalone legislation and an authority.
Thank you, Ms. Holt. It's speaking. Mr. Franklin has a question.
Thank you. I suspect my colleague may have a follow-up, but I really wanted to cut to the chase as I see it, which is, and I'll start with Councillor Dennis, but would be interested in the views of all three of you. Councillor Dennis, you've obviously talked about, I think very appropriately, the importance of cultural authority and speaking for country, and I totally understand that point. But could you perhaps speak to how that can be, that very important element can be incorporated into legislation?
Really, I suppose if we look at the processes around the Aboriginal Land Rights Act, and there are 120 local Aboriginal land councils across 9 regions. So really we have structures in place and we have standalone legislation. Every Aboriginal person right across the country have that cultural connection to land and to country. I suppose government policies and the removal of Aboriginal people, whether it be through the stolen generation, Aboriginal people are removed from one country and they are now living on other countries. So the complexity around which country do you belong to? And you know, as I say, the principles that we've agreed to as NTS Corp and ACHAC really goes to Aboriginal people speaking on country, and it must be led by Aboriginal people. The government need to be able to look at that structure and that legislative reform to build on existing structure. We've got native title structures and we've got land council structures. So there are existing structures in place. How do we actually strengthen this so that Aboriginal people are inclusive and be able to have that voice and protect what we have left? And really, as I say, we've done extensive work around the 2018 bill, and it was the government that come back to us and said it's too costly and it's too expensive to be able to protect. So, it's something that we've worked on for, all our lives really, and particularly over the last 40 years and groups, and it's more and more, the more mining that happens across our country, and the more development that happens across our country, what sites are left. And really, I suppose the Heritage Act does not offer all those protections to all of those sites because some sites are sacred and only community and local people know where those sites are. How do we actually build on those existing structures to be able to protect what is left? And we've worked closely with government to be able to do that. So how do we keep doing that? But again, not be divisive about which group to talk to and which one, but we've got to be able to stand, and we're halfway there in doing that.
Thanks, Councillor Dennis. I understand we're getting close to time, but if either Ms. Holt or Ms. Chalker had anything quickly they'd like to add, but if you wanted to talk in a more substantive way about how we can incorporate cultural authority and speaking for country into the legislation, you could certainly take that on notice if you had some more detailed thoughts. But if you had something short, noting time, then that would be wonderful as well.
Glenda, can I take that question on notice? But I just want to make a bit of a statement, if you don't mind. ATCHAC is committed to continuing working with Newswalk and NTS Corp to find an agreement with government. Our understanding is that whatever reforms come out of the current consultation, they will then go out for broader consultation with all Aboriginal people and Aboriginal communities across New South Wales, so that everyone can have a say in this process.
Thank you.
Thank you, Ms. Chalker. It's the chair speaking. Now, just prior, I was on mute and I was talking to Mr. Martin. Did you have something quickly to add? You're fine. Thank you. I'll take this opportunity then to thank our witnesses, Councillor Ann Dennis, Ms. Glenda Chalker and Ms. Mishka Holt, for your attendance today and for your participation. We appreciate that. There were a number of witnesses who decided to take some questions on notice. The committee has resolved that questions that answers to questions on that answers to questions taken on notice be returned within 21 days. The Secretariat will contact you in relation to the questions you have taken on notice. We will now be taking an extended break for lunch. We will resume at 2 p.m. A reminder to the committee members to place yourselves on mute and also ensure that your videos are turned off until that time. And we will be back at 2 p.m. Thanks again.
Thank you.
Thanks, everyone.
Thank you.
Hi. Hi.
Oh, that was fantastic.
Well, I've
There you go.
Thanks.
G'day, it's the chair here, Peter Poulos. Could I just ask the three witnesses who have just joined us to do a very quick sound check, starting with you, Miss Barletta.
Good afternoon. Nice to be with you all.
Thank you. And quick sound check as well with Mr. Tim Duddy.
Hello, Peter. Can you hear me?
Perfect. Thank you so much. And Mr. George Salouros, a quick sound check with you. Mr. Salouros, could you take yourself on mute and have another go?
My apologies, Chair. Yes, can you hear me now?
Perfect. Thank you. Well, good afternoon and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome our next witnesses, Ms. Penny Barletta, Mr. Tim Duddy, and Mr. George Salouros. Could each witness please state their name and position title and swear either an oath or affirmation? Starting off with Ms. Barletta.
Thank you, Chair. My name's Penny Barletta. I'm a manager for the Anglican Church Property Trust Diocese of Sydney and appearing today on their behalf and also for the Anglican Church Growth Corporation and Moore Theological College. And I'm going to take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Ms. Barletta. Could I now invite Mr. Tim Duddy?
Thank you very much. I'm Tim Duddy, and I'm former chair, now general manager of the Historic House Association of Australia. And I will swear an affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now and about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Duddy. And Mr. Salouros, could you proceed?
Thank you, Chair. I am George Salouros. I'm the Director of Asset Management, Planning and Projects for the Royal Botanic Gardens and Domain Trust, and was appearing here to represent, obviously, the trust and the interests of those lands. I'm taking the oath, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Would each of you like to start by providing a very short statement to the committee? Ms. Barletta?
Yeah, thank you for this opportunity. I'd like to start, if I could, by a quick recount of the story of St John's in Darlinghurst, which is one of our listed buildings. The first building on the site was a school hall, which was built in 1851. It was used for church meetings until the first stage of the church was completed in 1858. Then there were significant additions to the church building in 1866. The rectory was built in 1868, then 72, 75, 79, and 83. In 1903, the original school hall was knocked down and rebuilt, and in 1924, a side chapel was added inside the church. the war years kind of intervened to constrain any further development on the site. But in 1986, the site was state listed. And from that date on, the story of the buildings and the relationship of the buildings to the people changed. Because from that point, the buildings no longer responded to the needs of the people meeting on the site. Rather, the people had to respond to the needs of the buildings. But despite this, the history of the place continues to be made by the people who are an ongoing worshipping community there. A continuous community since that first date of 1851. I'd like to point out that a heritage listing would have us believe or pretend that heritage is something in the past and that it can be frozen by placing a listing on a building at a particular date. What that does, though, is ignore the fact that history continues to be created in a place by its ongoing use. And this is a challenge that we have as the owners of properties that have been in use since they were first built by us, sometimes centuries ago. But of course, today's community expectations are very different from the community that met in St John's initially in 1858. Different even to people who are meeting there in 1950. But what we find is nowadays we're constrained in our ability to update and upgrade our facilities to make them welcoming and functional places for communities that continue to meet on these sites. And that's really what we would like the ability to do. And we would like to have systems and processes that enable us to meet the expectations of the community outside the church, but primarily meet the needs of the communities that meets inside the church. Too often what we're finding is that our plans to alter buildings are actually constrained by these external pressures. Even though we may be seeking to upgrade them or to develop sites, spaces around these buildings to provide community facilities, social amenities, and also I acknowledge sometimes commercial facilities to enable us to continue to maintain the assets. Often the objections come from people who want to keep our buildings as points of historical interest. I've heard comments on historical tourism, cultural tourism. There's aesthetic value, obviously, green spaces in neighbourhoods that are provided by our buildings. But there's no balancing requirement for public contribution to their upkeep. The objects of the Act, as they stand, have the potential to deliver a more educated public, and this is one of those objects, but educated not just on the heritage of sites, but also on the cost of conservation and what it actually means to be the owner of a heritage site. Of course, we would like to see the public engaged more with our sites through perhaps a shared responsibility for that heritage management, but also in the ongoing history making that's occurring within the buildings. We note that the content of the Act doesn't quite address the object of promoting understanding because the reporting requirements that the Heritage Council is mandated to report on are pretty much related to the regulated protection of heritage, for example, through listings and orders and agreements that might be made. Just as a final point, we think the Heritage Council has the opportunity as one of the lead heritage entities in the state to show some exciting and creative leadership, which we hope would be followed by local councils in dealing with heritage properties that are already activated and in use. Reactivation and reuse don't mean much to us because we're already using our properties. We would like to partner with heritage entities to continue to make significant contributions in our state's history, as we intend to do. And we would like our buildings to continue this unfolding journey with us. Thank you.
Thank you, Ms. Belletta. Mr. Duddy, would you like to make a short statement?
I take it as read that the committee have seen our two submissions to the review. They are labelled one little a and one little b on your list of submissions. In 2014, the Historic Houses Association of Australia was formed to raise awareness for architecturally and historically significant historic houses. Our genesis lays in 1988 alongside the formation of the New South Wales Historic Houses Trust. It brought together the friends of some of Sydney's more important buildings such as Elizabeth Bay and Vaucluse House. And over that period, the friends were one of the most significant benefactors to the state-owned properties. Our fundraising contributed to their upkeep, maintenance and development, both in a hands-on with the work of the volunteers and the financial assistance that was taken advantage of by our fundraising activities. The HHA is a national member-based organisation. We are fully independent of government and a registered non-for-profit charity and have been granted DGR recognition from the federal government. We are predominantly a volunteer organisation with a growing membership and reach. Our goals are to educate, inform the public, to support private owners and work with the community to build an environment in which historic properties and places are supported, valued, preserved and enjoyed. We provide a platform, resources and expert advice to owners. We advocate on behalf to the government and we educate the public through a dynamic range of events and activities. We also support research to understand the special needs faced by owners of historic properties. And in 2018, we hosted our inaugural conference in Sydney, where these issues facing privately owned, historically significant houses were explored. This unique perspective allows the HHA to understand the issues that face both private and state-owned properties. Firstly, I'd like to put on the record that it's our view that the Heritage Act is a very good instrument as it stands. The issues arise with the institution's enforcements and skill sets and resources that surround it. These fail the Heritage and the Act and its capacity to preserve heritage and deliver good outcomes. Some of these issues that have been flagged amongst our peers are a lack of protection that is applied to state-owned properties. Once the mechanism of state significant development is applied, it appears that the Heritage Act, all its goals and aspirations are quickly forgotten. As part of our association's work, we run a range of international study tours. I have travelled extensively in the field and there are many examples of good heritage outcomes from around the world. For instance, in Rome, the property developers have made very significant contributions to heritage. The fundamental basis of all development is that they build around, repurpose, renew and repair everything. In a state where the view is that every developer, in many cases and architects, that are responsible for a tender which included the government, must start afresh from a flattened building site. Recent examples of the demolition of the award-winning Sydney Entertainment Centre, the removal of Willow Grove at Parramatta to make way for the new Powerhouse Museum site. Willow Grove is the last surviving Victorian Italianate riverside residence. One would ask how moving it to a suburban block in North Parramatta could possibly be seen as a good salvage outcome. It is this sort of project that had been contemplated in Rome. There would be no option other to incorporate Willow Grove into the museum development, thus allowing it to survive and remain relevant in its sense of place. This would also have been a great win for the community, who in many instances had stories about being born there or their parents born there in a previous incarnation as a private maternity hospital. Sense of place has become the new black in heritage and the discussions in heritage spheres. As set out in the Borough Charter, it covers Indigenous environmental heritage, something which has been tragically overlooked in the past, much to the peril of proper planning and the urban sprawl. Many of our historically significant landscapes have been completely overlooked and worse still ignored by bureaucracy and developers. Current examples are the Mulgullah Valley, the Varroville development of the Catholic Cemeteries Trust and the proposed now abandoned development of St John's Camden Horse Paddock as an aged care facility. To explore further, the HHA has branded our upcoming conference in 2023 as Sense of Place, discussing these issues to assist the government community in resolving some of these pressing challenges. I'll touch briefly on some of the other issues that have been raised at our base, slightly outside the purview of your review, however, very relevant additional input. Climate change is affecting our heritage from a built and regional perspective. The COVID-19 crisis means that more than ever, we should be looking towards state and regional tourism opportunities and proper protection of heritage will keep regional communities attractive and local, and when the world is open to international tourism. Government should not be allowed to assess its own applications. They should be carried out by an arm's length independent body free of political influence. OEH should comprise of skill-based planners to deal with planning, registered heritage architects to deal with architectural significance. The resounding feedback has been that it is populated mainly by archaeologists, a science that is not based on preservation, but rather ways of recording loss, or graduates without practical experience in the field. Conservation management plans should not be volumes of information. They should be simplified, one-touch documents that are constructed from a template. They should identify, preserve, and encourage owners to achieve better outcomes. Private owners of state-significant buildings usually have the best intentions regarding heritage. Damage often occurs through ignorance rather than malice. There should be a less adversarial process in dealing to remedy these situations. Across the state, local government should be properly resourced to deal with heritage issues, either from a centralised regional group or of councils, or with the assistance of the state government department. Once a built and natural heritage is destroyed, there is no turning back, and the time to act is today, and we welcome this review.
Thank you very much, Mr. Duddy, and I'll invite Mr. Salouros if you could provide a very brief statement.
Thank you, Chair. Thank you to the committee, and thank you for the opportunity to be able to present the comments from the Royal Botanic Gardens and Domain Trust. Let me preface by saying many of the elements that have been raised by the preceding speakers are very common to our organisation as well, in various forms and elements and with various strengths. The Royal Botanic Gardens is Australia's oldest scientific institution. It was established in 1816. It is the second oldest botanic garden in the Southern Hemisphere. And for those that are familiar with gardens, also predates the Royal Botanic Gardens in Kew in England, which is the world's #1 rated botanic garden globally. The Trust and our whole issue in this space is that we are obviously, as a scientific institution, curate a living collection. And these are key factors in understanding the purpose of what the gardens is and the domain within the space, both as a public space that can be open for recreation and access, but also the fact that it benefits scientific research. It is not a normal parkland. And I think these are key factors that the committee should consider. We are also among the top 10 most visited botanic gardens in the world, with international visitation and domestic visitation just into the gardens themselves, excluding the domain, of over 5.5 million people per annum pre-COVID. Even in the COVID environment, we are still having over 3.5 million visits into the space of the Royal Botanic Gardens, even in the height of the COVID scenario, as people seek to break out and exercise where they can under current restrictions. Like an art gallery, and I think this is a key point to note, our gardens and spaces are essential to maintain relevance and to meet the objects of our Act, of which our Act addresses the requirements for science, horticulture, education and recreation. Like an art gallery, the value of a gallery is obviously assessed by how often it puts on new exhibitions and its ability to change its displays and its information that it puts out to the public, therefore maintaining relevance. From a personal experience, I could probably state to you that before I became a director in the gardens, my last visit to the gardens was as a 14-year-old with my family. And then I attended nearly 40 years later. Why? Because the gardens had not changed or modified or kept pace and can provide some form of attraction or interest. And among these things, and these are the considerations, is that within the Heritage Act, with a very broad reach in terms of some of the categories that are applied, and the level of expertise, there's been experiences in the past which have prevented changes to things like the trees, the plants, and obviously the need to move and adjust structures. As a key point, I think I would flag is that because it's a scientific collection, the category approach, that is one thing that the committee is looking at, is something that would be most applicable to take on the nuances of a botanic gardens in the space of the state significance of the heritage assets that it holds. It holds both scientific collection as well as broader collections of interest to the public. So We rely heavily on visitation. It continues to support our ongoing viability, and particularly in these particular difficult times. And while the need is within our conservation management plans, the structures to maintain elements of picturesque or garden-esque architecture, landscape and design, we found that in the past there've been almost a sense of freezing the gardens in time. And I would probably say to the committee that a garden frozen in time is a dying garden, because there's nothing to attract visitation and keep renewing the space and keep bringing people into the space, and therefore meeting our objects of education, research, and recreation and science. The other key factor, I think, is that we need to be able to be quite flexible. I've emphasised quite heavily the need for our living collection, our trees, our garden beds, our displays and so forth. But all of those are heavily reliant on the infrastructure that sits around them and supports them. For us to not be able to do a renewal of our in-ground irrigation systems, or for that matter, place and install irrigation systems without having to go through a heritage approval process, is anathema to being able to support the outcomes of the garden. There are certain constraints and there are certain limitations, and the Trust has no qualm with the approaches to the built infrastructure, the buildings, the footprint that is clearly established, set in stone, whether it goes back to our 1838 Domain Depot on St Mary's Road, right through to our somewhat brutal 1979 constructed brown building, which is currently housing our herbarium collection. So within these parameters, the Heritage Act does give us some clear guidance. There are some dispensations for temporary works and the capacity to do things, but it needs to be looked at in the objects of the Trust. The Trust has over 200 years of experience in managing and looking after these assets, invests quite heavily with whatever recurrent funding it has and capital funding from government to maintain these as assets and facilities of the state, but also needs the capacity to be able to use that space to attract people. Those of you that sit in Parliament are well aware of the event sequences that take place in the Domain, the concerts, the Christmas and carols in the Domain, and all these other social and cultural activities. Anything that tries to curtail or restrict those within the broader definition of trying to contribute to the cultural benefits can also be negative to the heritage impact, because again, we're trying to work on space frozen in time. I urge the committee to consider the options in terms of particular uses and nuances in terms of the review, to look in particular at the category approach as one of the items that may come out of this, and to consider the number of agencies, the Royal Botanic Gardens inclusive, which includes scientists, botanists, horticulturists, arborists, and that is their specialisation, have devoted their lives to that site and would not be an organisation that would seek to dismiss its heritage blindly in doing any works into that space. I thank the committee.
Thank you, Mr. Salouros. And now I'll just invite members of the opposition if they have questions. The Honourable Peter Primrose.
Yes, can I just ask one to Mr. Duddy, please? If I go to page 2 of your supplementary submission, about halfway down, you say you support a reduction in the burden of owning a residence on the State Heritage Register, but oppose the proposed system of categories as a way to achieve this. Can you please just elucidate that and talk in a bit more detail about what you'd actually like to see in its place?
So that's referring to the concept of involving a local government authority or a much more hands-on face-to-face interaction that deals with the challenges that surround these houses in a pragmatic fashion. To suddenly have a building, a house that you purchase that has a 300-page conservation management plan that is attached to it, and many of those things don't actually go to practically preserving the fabric of the house. If you need to replace a downwater pipe, you would need to get an archaeologist to move 1 metre of pipe to oversee the excavation works in that space. Those things practically don't work in a private residence. So dealing with a one-touch conservation management plan, as I alluded to earlier, where they are done from templates and people very clearly understand what their obligations are. There were some stories in some of the houses in the rocks where they lifted floors and they had to keep the dust from under the floors that was removed, and it had to be removed by an archaeologist. These things are not practical in a domestic setting. And if the government was doing something to one of their own buildings, such as the Lands Department building that they're contemplating using as a hotel, they would not have those imposts.
So when you're talking about this, you're talking about it being less specific and less prescriptive. Is that correct?
No, I'm talking about it being very clear, but it being a simpler process where things are looked at in I suppose, yes, to answer your question, yes, less specific, but looking at things in a general format that work on overall protections, not on minutiae.
Okay, thank you, Mr. Chair.
Other questions from the opposition? Mr. Buttigieg.
Thank you, Chair. Just briefly, there seemed to be a theme from the submission, from the opening statements that I guess the catchphrase we've been using to describe it is adaptive reuse, or in other words, better engagement with the public for use in real time to then foster the longevity and appreciation of the asset. I just wonder what people's views are on the ability of the Act to achieve that as currently configured, and whether or not it needs alteration to achieve that objective.
I'm happy to have a go at that. As we suggested in our submission, it's actually not the Act that's deficient in that space. It is the design of the bureaucracy around executing that Act, where you have people working in that bureaucracy that are not practitioners of the fields in which they are making the rules about. The OEH is very, very, very heavily weighted towards archaeology. You can't have an archaeologist making a decision about how you deal with a damp wall. It's not the thing you do. You also have people that have got extraordinary academic qualification, but very little hands-on experience in working in the field. So it's not the Act that's the problem, it's the way that the bureaucracy is designed surrounding it.
Mr. Soloros, did you wish to add a point?
Thank you, Chair. I'd like to reflect on what Mr. Duddy has just stated. The challenges we face, and I'll specifically respond to the Royal Botanic Gardens in this case, is the Royal Botanic Gardens over time started off, believe it or not, from Farm Cove in its original origins as one of Sydney's tips. So the reality is that, you know, from that whole space, we've got that wonderful Farm Cove seawall and view over Sydney Harbour over time, but it was a landfill project. Across the gardens and across the domain, those areas have been repeatedly disturbed over 200 years through various works, whether it's, you know, planting, replanting, lifting things up, moving things around, putting in pipes, running electricity when that was introduced into Sydney, you know, running gas supplies and rainwater lines. You know, the Carl Expressway and Eastern Distributor tearing quite a large scar between the domain and the gardens as it currently stands. So talking to process, should we be considering anything to do with an application to even do some minor works? As an example, I wish to put in 2 turnstiles at 2 of our gates to provide ease of egress for people out of the gardens at night when the gardens get locked. People invariably stay behind. The rangers have locked the gates and then people need to get out. To put those in, we go through a Section 60 application. Perfectly fine, perfectly acceptable, perfectly understandable. But when we also start getting inquiries about to do a Aboriginal impact statement and a assessment on the terrain and the archaeological elements as part of the criteria to an area that has been repeatedly disturbed over the years, the value of continuously investing in that area is almost, dare I say, keeping an industry going, when in effect there should be just a review of understanding that you have particular areas that have been grossly and significantly disturbed, and you have areas which are pristine or have not been disturbed for extensive periods of time. The nuanced approach that has been referred to would allow that level of granularity and that level of flexibility without having to keep reinvesting into the background of this. Thank you, Chair.
Thank you, Mr. Salouros. Any other? I just noticed Ms. Barletta raised her hand. She'd like to add some points, and then I'll invite the opposition to raise another question.
Yes, I'd just like to invite the committee to take a step backwards from the details of the Act and note that while the objects of the Act, I pointed this out in my introduction, the first is to promote an understanding of the state's heritage, then to encourage the conservation of the state's heritage, a couple of points that I think are quite well covered in the Act, and then to encourage the adaptive reuse of items of state heritage significance. A survey, and I did this very quickly and not completely, of the actual contents of the Act point out that most of the Act actually addresses objects C and D to provide for identification registration and the interim protection of items of state heritage significance. So I think there's an opportunity to take a higher level look at the Act itself against those objects, if they are in fact to remain the objects of the Act, and see how the document actually meets up with the stated intention of the document. And further to that, it's an old adage that that which is assessed is what attention is paid to. I think you'll find in Division 2, the Heritage Council are required to report to the Minister. I'm looking for this. Annual report, and the report's contents are to include a summary of recommendations, advice and opinions under the following provisions: interim heritage orders, direct listings, removal of items, heritage agreements, advice on shipwrecks, and orders restricting harm to buildings, stop work orders, deletions in a state heritage register, and finally, particulars of financial assistance as is provided. There's nothing there referring, I think, to any action of the Heritage Council that might promote understanding or encourage rather than legislate for preservation. So I think it might be worth stepping back a little bit from the details of the Act and in fact how that process plays out in the real world to look at whether the Act is reflecting all of the objects. Thank you.
Mr. Buttigieg, have you concluded your questions? Reverend Noel, Mr. Shoebridge, did you have a question?
Yes, I do. It's Reverend Fred Noel. A question for Ms. Barletta. In your submissions, 49 and 64, you stated that your application to add a services building on a city site with 2 listed buildings and little free space was rejected without even a Heritage New South Wales assessor even visiting the site or discussing options or advice on what would be permitted. Would it be a benefit to mandate that heritage assessors have to at least visit a site and propose options and give advice before an application can be declined or rejected?
I believe that the volunteers who manage our heritage sites would very much welcome visits by heritage advisors before decisions are made. Another case that we referenced was from a country church which struggled to get a positive result on an application, again without a visit from an assessor. And they suggested that perhaps advice from local heritage experts could be taken into consideration rather than requiring somebody. I understand this is a Mossvale church. It's a way to travel, we understand that. A little bit more disappointing that the trip wasn't able to be made to a Sydney church in the centre of the city, essentially, in that circumstance. But certainly I know that the volunteers who manage our churches would appreciate earlier and more engagement from people undertaking those roles.
Thank you, Ms.
I
Boletta.
also note the issues you had with, yes, thank you. I note the issues you had with the replacement of a church roof and the development of a light neighbouring a listed property. And the recommendations you noted all seem very logical and should be seriously considered. Is there anything further you would like to add to improve the operation of this system? Thank you.
I think one of the things that we note and needs to be acknowledged, that many of the challenges we have are with local councils rather than with the state heritage system, and the I guess the separation of responsibilities between those two bodies is perhaps not always helpful. We see that the Heritage Council has the potential to, or in fact does, lead in heritage matters, and that's where I guess we'd like to see some more attention being given to ways forward that open up opportunities for sites. One of the examples that we used was St Jude's in Melbourne. Unfortunately, that the church, which is on the register, the Heritage Register in Victoria, suffered a fire. But the fire made way for significant and very sympathetic development, which has given that church a whole new lease of life. It would be helpful to find ways to operate with our listed properties at local or at state level in order to provide the kind of amenity that was made available through that very unfortunate circumstance without having to have our buildings burnt down. But actually provide a little bit more flexibility on our sites so that they can continue to tell the story of Christianity in our state rather than consigning it to the history books, because that just doesn't accurately reflect what is going on.
Thank you.
Thank you.
Just one final question.
Yes, Reverend Noel.
In your submission number 64, you point out that from a Christian perspective, we value people and action significantly above our church buildings. We feel that we are being constrained in the redevelopment of our site for church education and social infrastructure use by heritage rules that more serve the secular community. We do not use our assets at the expense of more high quality ministry and charitable works. You outlined the St Jude Anglican Church example. How did the process of the Victorian Heritage Assessment differ from the New South Wales Heritage Assessment? How was it an improvement?
Thank you for the question, Reverend Niall. I'm afraid I don't have the details of the difference between the two assessment processes, but I'm very happy to research that and get back to you if I could take that question on notice.
Thank you, Ms. Boletta. That'll be fine. We'll note that. I'll go to Mr. Shoebridge now.
Oh, thanks, Mr. Chair. Well, my first question is Mr. Salouris. Salouris, the submission we have from the Royal Botanic Gardens is signed by you as the Director of Asset Management. Was it adopted by the Trust and the trustees?
Sorry, Mr. Shoebridge, in the sense that this has been approved by the Trust to be issued, is the question?
Yes. Did it go to the trustees and did they adopt it?
So this is information that has come back through advice, which, you know, I've been able to exercise through my authority and my delegation through my chief executive. So it hasn't necessarily gone up to the trust as a direct document for the board's review and comment.
Has it gone up as an indirect document?
No, not yet.
If you're talking about amendments, fundamental amendments to the Heritage Act, don't you think that's something that the trust itself, the 7 appointed trust members, should have had input in for something as important as amendments to the Heritage Act, coming from an organisation as culturally important as the Royal Botanic Gardens?
The answer to that one, Mr. Shoebridge, is that, you know, as a director, I have certain delegations to manage. The planning and commentary on impact and legislation sits within my area of responsibility, and therefore it's been done along those lines.
What's the commercial activity that you've wanted to undertake in the Royal Botanic Gardens that you feel the Heritage Act has prevented you doing?
So within our areas, we'd look to the adaptive reuse. We have a number of cottages which have some residential background and history. So the Domain Depot is one, Victoria Lodge is another, Rathbourne Lodge, which is currently used as our education offices, and Liongate Lodge. All these used to be former residences that were part of the curators or the custodians or the superintendents that lived on site prior to you know, legislative changes back in the 1980s. So these are areas that have the potential to create an adaptive reuse, including a food and beverage outlet where the heritage value is recognised within the space, but also allows the development to reflect and take advantage of these areas. I might point out to the committee that the Royal Botanic Gardens is roughly pre-COVID half funded through government grant, and the rest is dependent on its commercial revenue to support its primary functions of science, education, research, and horticulture. And so opportunities to be able to increase that revenue and reduce the reliance, if possible, on government grants would be of a benefit not only to the gardens and the trust in delivering its objects, but there's an indirect benefit to the state as it draws less on the public purse.
So you want to hire out those 3 buildings for commercial uses of restaurants and the like. Is that the limit? Because you referenced the what happens in the domain, and it sounded as though you also wanted to commercialise by way of short leases or festivals or the like, some of the green open space in the Royal Botanic Gardens. Are you saying it's only limited to trying to get some restaurants and other similar facilities to those?
Anything that would attract and keep the visitation. The one thing I would like the committee to be aware of is that in a space such as the Botanic Gardens, what happens is that it's a free entry Botanic Gardens. That was a decision of government that was made a number of years ago. So as a result, the visitation has quite rightly gone through the roof. Free entry tends to mean, therefore, there's a greater interest of people moving through the space. In fact, what is actually done with that is then increase the operating cost of the gardens, the waste removal that generates out of it, the cleaning of public amenities and so forth. So the benefit, I think, from all of this is to be able to at least get the best possible use out of any space, right? And I'll reflect the term best possible use within the restrictions and the limitations of legislation and the Act, but which allows us to deliver those greater benefits that we see to the community.
Mr. Soloris, this push for the greater commercialisation of the Royal Botanic Gardens, do you have the endorsement of the trustees for this push that you're bringing to this committee?
Mr. Shoebridge, the answer to that question is that each matter is assessed in its own approach. We had approached to the board questions about what we can do and what we can explore with each of our facilities. None of those were accepted by the board. The board has asked the executive to review and come back with any other options and be able to come back to the board with any ideas and suggestions to look at that. There is no carte blanche, go ahead and commercialise type statement. The board is very active and very diligent in overseeing those objectives and trying to make sure it aligns with our objects and our responsibilities.
Given the board hasn't supported your previous efforts for increased commercialisation of the Royal Botanic Gardens, don't you think it would have been prudent to have gone to the board before you brought this submission before the committee to try and find avenues for additional commercialisation of the Royal Botanic Gardens?
Mr. Shoebridge, the board is recognising and quite cognizant of the issues that we deal with trying to obtain revenue, obtain grants and obtain funding to support our operations. In these particular matters, these are a balancing act. In taking this to the heritage, to this inquiry, is to understand some of the issues that are confronted that go through the process. Commercialisation is not the only outcome. The ability to say convert an existing building into an education building or a facility or something that facilitates greater access for school excursions. These are all things that can be part of the act. The issue from the inquiry and the perspective is not simply the commercialisation, but it's the best use that we can make of our heritage assets and the mechanisms through which we can pursue that.
It's the chair.
Mr. Duddy, I might go to you very briefly.
Very briefly, Mr. Shoebridge.
Mr. Duddy, we've had a number of submissions concerned about the lack of independent resources to the Heritage Council and the fact that by reason of the Heritage Council having to depend upon government agency staff, that there's a conflict of interest or a lack of independence, depending on how you characterise it. Do you have a view about that? And do you think we should be recommending independent resourcing for the Heritage Council?
Absolutely. I think that's an essential part of the proper process. And I think also asking the broader community to put up representatives that the community agree to is also a very good process, as you would do with any other committee.
It's the chair speaking. Thank you, Mr. Duddy. I'll invite government members to raise a question and acknowledge the Honourable Taylor Martin.
Thank you, Chair. My first question is directed probably best with Ms. Barletta. Your submission mentions challenges with the heritage approvals process. Would you be able to expand a bit more on this and on any particular areas of that process that you believe, or your organisation rather believes, could be improved on?
Thanks, Mr. Martin. First, perhaps I should point out that I reached out to the volunteers who manage our heritage assets for their reports of their contributions. So I'm one step removed from that process. I believe that there is a resourcing issue, that it is difficult to connect in with the Heritage Office and have consistency, even with people dealing with one matter over time. It takes a long time for things to be dealt with. I think the Act allows up to a year for a response in some places. I've experienced what I would consider overreach in the Heritage Office officials making their opinions known about what the heritage outcomes should be. That's a concern. So there are a range of issues that have come up in my conversations with parishioners who are dealing with the Heritage Office particularly, and also some of my own direct experience. Does that help?
Sure. If we can move on for a moment, and I'll let my colleagues ask. What kind of incentives do you believe might encourage heritage property owners to better conserve their state heritage listed items?
Is that a question for me, Mr. Martin?
For all, but I'll start with you.
Sure. Look, we are some of the incentives that are offered to heritage owners don't impact us. Our churches are not rated, we don't pay land tax. So there's certainly a consideration there of the social impact of churches that is obviously to our advantage as landowners. I think the most meaningful incentive, obviously, we'd like more grants to be available and more grant funding to be made available. That would make a big difference. Our Heritage Advisor, Mr. Davies, has suggested that perhaps targeted funding and the management of funding through a program of works across our buildings would possibly be something worth exploring. as a way of managing, I understand, limited funding. I think perhaps a disincentive for people to list or propose listings. If there was some kind of responsibility for those who are proposing listings to actually contribute in some way to their upkeep, I think that would be a just way to deal with heritage listings, which right now can be made with or recommended with no impost on the person making the proposal. But key for us is the opportunity to use our land more flexibly than heritage listings, particularly at a local level. I think our state heritage listed churches are very well maintained and cared for by the local congregations, and I certainly don't get the push for those to be developed. We have had some success, but certainly the opportunities at the local level to make better use of our land through development would be invaluable to us.
Thank you. I'm just conscious of time, so I might move on to my colleagues. Thank you.
Thank you. Mr. Mallard has a question.
Thank you, Mr. Chair. Shane Mallard speaking here, and my questions are directed to Mr. Salouros from the RBG. I just note, not that it's a conflict, that I spent a couple of years on the board of the Centennial Park Moore Park Trust, which had a very close relationship with the Royal Botanic Gardens and Domain Trust. And one of the things, picking up on the issue of commercial opportunities for the Botanic Gardens, and you mentioned it's 50-50, the funding split roughly between government grants and revenue that's raised through activities in the Botanic Gardens, is that it is clearly in the interest of the Royal Botanic Gardens for you to maximise opportunities for sensitive commercial development to reduce your reliance upon government grants. Would you acknowledge that?
Yes, I do, Mr. Mallard. I would probably also add that prior to the decoupling of the Royal Botanic Gardens from Centennial Park, my role was to sit on the Group Botanic Gardens Centennial Parklands Agency, where Centennial Park was one of my estates that I was also responsible for management. I'd probably like to bring to the committee's attention the question I think that drives many of these things. Centennial Park is an organisation that has an economic engine that's been provided to it through the Entertainment Quarter, Fox Studios,
and the Golf Club.
Yeah, all those other areas. The Royal Botanic Gardens does not have such an economic engine, and therefore relies very much on its capacity to do that. So consequently, Centennial Park has been pretty much self-sufficient in terms of its operating requirements, and continues to be so post the decoupling and integration with Greater Sydney Parklands. But the Royal Botanic Gardens is still in that position where it does not have that economic driver, whether it's on trust lands or associated with trust lands, to be able to support and underwrite its activities.
Well, the Greiner government was the government that did the reforms to align the domain to the Botanic Gardens as an opportunity for revenue, and the Centennial Park and the Moore Park precinct for that reason. But prior to that, you'd acknowledge that in difficult times for government, both parklands were totally underfunded and in poor condition.
So in terms of the funding, I would probably highlight that COVID has had a significant impact. You know, there is a significant operation there for the Royal Botanic Gardens in the sense of the parking revenue from the Domain car park, the impact of the food and beverage outlets that are existing operations within the gardens. All of these have a continuing impact and lead to the Royal Botanic Gardens. I cannot speak now to Centennial Park, but the Royal Botanic Gardens being a question of going concern. However, having said that, wherever the government has been able to support capital funding to renew and refresh assets, the government has done so through the normal government process based on the forward estimates over 4 years.
Right. My final question is, recall a few years ago, and I was a councillor in the City of Sydney, so we were consulted in this one, the work to remove, and it was lots of attempts, lots of failed attempts, but to remove the flying foxes, a protected species, from the 200-year-old rainforest in the gully there in the middle of the Botanic Gardens. And there was a lot of talk about them being heritage listed, but of course the trees weren't heritage listed. the category of landscape category for within the new categories for heritage recognition, would that benefit for in a process, for example, like that, where it was a difficult process, but people need to understand that we're weighing up a heritage landscape against other interests?
I'd probably say, Mr. Mallard, that it's always an exercise of balance. The colony that you referred to, at one stage, I know in my time at Centennial Park, grew to 90,000 flying foxes and became
Killing the trees, killing the 200-year-old trees.
And therefore killing off the melaleucas and the paper barks that were in the gully at Centennial Park. As they forage for food, they forage far and wide, and come to the Botanic Gardens because of the fig trees, and the fig trees in Centennial Park, for that matter. There's always been a balance act between that. We recognise that the issues that come over the top of it, animals will extend boundaries, and those that can fly will definitely extend any land boundaries that may be present. I would probably say that from our perspective, and conscious in the sense of the heritage values that we speak of, the things that tie Centennial Park and the Royal Botanic Gardens together is Charles Moore, who was one of the directors of the gardens and superintendent of Centennial Park. Therefore, there are common thematic themes between the estates. The colony rises and falls based on conditions. I'd probably also flag that the climate change statement that was made by one of the previous proponents is also a concern for us as development takes place around the gardens and the domain. Concerns about the sun plane and its impact, the ability of reflectivity of surfaces into that space. These will affect trees. These will affect the vegetation. These will affect the wildlife.
Dolores, I better hand in my colleague Ben Franklin. I could talk about the Botanic Gardens all day, but my colleague had a quick question in 1 minute to go.
And this will be a very quick one, Mr. Franklin. Thank you, Mr. Mallard.
That's okay. I'll put mine on notice, Mr. Chair. No problem at all.
Thank you for your assistance, Mr. Franklin. I'll take this opportunity to thank Ms. Balletta, Mr. Duddy, and Mr. Salouros for attending this hearing and for your participation. We appreciate your input. I recognise that Ms. Balletta has agreed to take a question on notice. The committee has resolved that answers to questions taken on notice be returned within 21 days. The Secretariat will contact you in relation to the questions you have taken on notice. Now, members of the committee will take a very quick break to assist with the changeover of witnesses. I invite committee members to ensure you're on mute and switch your videos off. I will remain with my video on to help facilitate the sound check of the other witnesses when they come on. We will resume at 3 o'clock. Thank you.
Thank you, Chair.
Thank you, Chair.
Few minutes.
Sure.
I'll give the screen a break as well. It's not doing well, as you can see.
No, it looks like it's
It's the chair speaking, Peter Poulos. Could I just ask our three witnesses who've just joined us, Mr. Beatty, Mr. Abrahams, and Ms. Seidler, could we conduct a very quick sound check, starting off with Mr. Beatty?
I'm just unmuted now. Can you hear me okay, Mr. Chair?
Just a little louder, if you don't mind.
Is that any better, Mr. Chair?
Perfect, thank you. Mr. Abrahams?
Good afternoon, Chair.
Perfect, thank you. And Ms. Seidler, could we have a quick sound check?
Hello? Yes, sorry, I'm trying to get my video to work. Apologies.
Well, I can certainly hear you.
Okay, apologies. I'm not sure why the video is not working. Hold on, start video. Oh wait, oh, there we go. Can you hear me? All good?
Right, yeah, fantastic, coming through loud and clear. We will start shortly.
Thank you.
I just might ask Mr. Beatty for another quick sound check. Do you mind just raising the volume just a little more, please?
Is that any better?
It is, it's improving, thank you.
Terrific, thank you.
Well, good afternoon and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome our next witnesses, Mr. Stephen Beatty, Mr. Hector Abrahams, and Ms. Polly Seidler. Could each witness please state their name and position title and swear either an oath or affirmation? And I'll invite Mr. Beatty to start us off.
Good afternoon, I'm Stephen John Beatty. I'm an architect at EJE Architecture. And my oath, I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Beatty. Mr. Abrahams, please.
Good afternoon. I'm Hector Charles Abrahams, registered architect. I represent the Australian Institute of Architects New South Wales chapter. Here is my oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr. Abrahams. And Ms. Seidler.
Yes, I'm Polly Seidler. I'm in-house lawyer and Harry Seidler, fact liaison checker person, architectural historian. I promise before Almighty God that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Would each of you like to start by providing the committee with a very short statement, because I'm mindful of time? I invite Mr. Beatty, if he'd like to start us off, If you wish to, could I ask you just to move a little closer to the microphone and provide that statement? Thank you.
Sure. I've told you my name's Stephen Beatty. I've been working predominantly in heritage projects for the last 5.5 years. The active use of heritage items is critical. If an item is not in use, it's not able to actively demonstrate its significance. We enjoy working with the significance of a place along with the capabilities of its owners to arrive at solutions which keep items useful and contributing to their communities. We agree with the purposes of the Heritage Act 1977, but often encounter difficulties with mechanisms involved in conservation applications. These difficulties can stall projects and items can lose their active use. So we welcome this opportunity to contribute to this review of the Heritage Act and hope that it will make the pursuit of conserving our heritage easier into the future, thus maintaining its active use and contribution to communities. Thank you.
Thank you very much, Mr. Beatty. And could I ask Mr. Abrahams, would you like to provide a short statement?
The Australian Institute of Architects New South Wales chapter are very pleased to present their detailed submission. Next to that of the Department of Planning, Australia Ecomos and Sheridan Burke, ours is among the broadest of those you've received because architects are deeply involved at the practical level, and I commend it to you. I've read more than 60% of the submissions and all the main ones. The evidence, lots of evidence has been given to you about the issues raised prospectively in our discussion paper, and there's a very low level of gripe. How might you respond as legislators? Along with the National Parks and Wildlife Act of 1974, the Heritage Act of 1977 is the oldest legislation in the modern era about the environment. It predates the Environmental Planning and Assessment Act and the State Environmental Planning Policies. And God willing, we'll soon have an Aboriginal Heritage Act as well. These later acts define their relation to the Heritage Act, but the Heritage Act does not relate members, it's defined its relationship to them. Many of the operational issues in the submissions before you arise from lack of definition between the Act and its later influential heritage cousins. The Heritage Office did not exist when the Act was written. As legislators, you could seriously improve our management of our environment and heritage by working on these relationships, and the Institute would be very pleased to collaborate with you on that. Architects live with the reality of environmental legislation all our lives for our clients and the public good, and we wish you well in your endeavours.
Thank you very much, Mr. Abrahams. Ms. Seidler, did you wish to make a short statement?
Yes, I'm Polly Seidler. I'm the daughter of the late modern architect Harry Seidler, award-winning buildings from over a 60-year period after 1950, some local and state heritage listed. I speak actually as both a property owner of heritage buildings and someone concerned about modern architecture heritage. Sometimes that seemed to be a conflict, but I have experience of both ends of the spectrum. As a building owner, there is currently a procedural burden which non-heritage owners do not have for repairs and upgrades. Unlike in Victoria, where you can get a heritage approval and then a complying development consent, in New South Wales, if it's locally listed, it has to be a full DA, even if the heritage officer approves the works you're doing. I'd like to say that also the current assumptions behind heritage is that buildings with their original use.
I'll have that submission because
please continue, Ms. Seidler.
Okay, buildings with their original use, which have good design, the purpose of why they're going to be heritage listed, seem to be penalised, particularly if they're a commercial office building. And they're treated as if they're an artefact and stumbling blocks to get new tenants having to do full DAs and the like. I do think there are current issues of non-architects making heritage decisions about architecture. The focus on materials, like for like, is not the solution for a lot of modern architecture heritage, particularly my father's work. There's a lot of factual inaccuracy and sloppiness in heritage listings. I've had to swear the truth before you today, yet these heritage listings burden property owners. They're often sloppily written, and there's no accountability for the sloppiness that is written. There's no excuse. The sources are on the public record, but people are like doing a last-minute assignment. One thing that I think the Heritage Act does need to take into consideration is a lot of heritage buildings are also under copyright now for where architects died 1955 or later. And this also brings rise to issues of architectural integrity and architectural attribution under the federal legislation, moral rights of artistic integrity. And unfortunately, the heritage world in New South Wales operates as if these federal laws do not apply to decisions that they're authorising. As to financial incentives, issues to do with land tax, waiving stamp duty on insurance, local council rates, there are various New South Wales revenue aspects that could help to subsidise heritage. I also want to plead for proper resourcing of the New South Wales Heritage Office staff. I believe that they do not have enough staff, causing delays in listings and buildings being ruined or demolished in the interim, and inappropriate works being authorised that ruin the heritage significance. Thank you.
Thank you very much, Ms. Seidler. Members of the opposition, do you wish to raise some questions?
Yes, if I can.
The Honourable Peter Primrose, thank you.
Just one at this point to Mr. Abrahams. I'm looking at page 10 of your submission, your answer to question 18. How could we improve the heritage tourism or help activate heritage places for tourism? And your last paragraph states that it should be noted that tourism trends are often very short-lived. Great care should be exercised in assessing the fit to the heritage place. I was wondering if you could elucidate on that, please, and also talk about how you would ensure that the fit was actually exercised.
Thank you for your question. It's a tourism and heritage do go very well together. The Opera House would be the key example of that. It's the most visited place in Australia, and it's on the World Heritage listing. It would not be on the World Heritage listing if it did not have protection first under the New South Wales Heritage Act. So one of the roles of the Heritage Act is actually to support tourism by acknowledgement and recognition. I think that's a good example for you. Examples where it is not is really where it's not thought about carefully enough, and you get examples where a town might be tinselled up for tourism at the expense of its heritage. So there's a lot of pressure on some heritage towns, such as Morpeth in the Hunter Valley, Tinga, where the pressure for tourism is not the friend of heritage. And those examples, the Heritage Office and the Heritage Act plays a role in tempering that relationship between tourism and the basic value of the place.
Nothing specific in relation to great care, or just that people should be alert to it?
The Heritage Act does control what happens in places, and the Heritage Office does have control mechanisms. So in places like Morpeth and the Rocks, for instance, they are trying their best to exercise that control in the right level of balance. So I think wisdom is needed in the heritage control part of the Act. I think it's very important how appointments are made and how not only in the Heritage Council but in the Heritage Office, so that there's great wisdom. I think some of the gripes arise from the processes of the Heritage Act not being wisely played out.
Thank you. May I simply ask, Mr. Chair, if either of the other two witnesses have any comments that they may wish to make on that point?
Thank you, Mr. Primrose. I'll go firstly to Ms. Seidler, who raised her hand, and then I'll invite Mr. Beatty to also provide any input.
Yes, with tourism, there has to be, people forget not only the building fabric, but likewise the side, shall I say, services for tourism. The place for a heritage owner, you know, where are the tourists going to, you know, where do they park? Where, you know, where are the toilets? Where do they get a cup of coffee? That sort of side aspect is also can denigrate the original heritage item, and also has to be managed, but it is also a capital expenditure which has to then be recouped with the tourist dollars. But it's something, and the pressure then is on owners to, for instance, the Rose Seidler House, they're wanting to shut it down. That, just for the record, Rose Seidler House is a part of the properties of the Historic Houses Trust, a state government entity, now branded as Sydney Living Museums. The pressure is they want to close it for half a year and have it for dining venues with replica furniture. Now, apart from the intellectual property issues, there are cultural integrity issues with this pressure to lease it out for commercial operators to have a pseudo tourism event.
Thank you, Ms. Seidler. Mr. Beatty, did you wish to respond as well to Mr. Primrose's question?
Yeah, short answer, Mr. Chair. Thank you. We alluded to this a little in our report as well. We only noted that it's the business case of what you might use something for to bring the tourists in. We can't sort of condone so many coffee shops all lined up together. There has to be a business case in there to support the use of the item, and that has to be prolonged so it doesn't sort of lose that use in a couple of years' time, and then we have to go back to the start to refurbish it again.
Thank you, Chair.
Thank you, Mr. Primrose. Are there any other questions from the opposition? Mr. Buttigieg.
Thank you, Chair. I wonder if witnesses have a view on the composition of the Heritage Council and the people on that body. We've heard varying degrees of evidence about the appropriateness of expertise and also the perception of independence from government. I just wondered if you've got views on that.
I'll go for, it's the chair speaking. I'll go firstly to Ms. Seidler, followed by Mr. Abrahams.
Well, I haven't looked at the current members of the committee. I'm concerned about the lack of people with architectural understanding at all. I have seen on the, I guess for the Heritage Register Committee, I don't understand why someone who's worked at Ausgrid and is a healthcare administration or as a planning lawyer is making the decisions of what is to be our cultural architectural heritage. No other country in the world would have people making, you'd want trained curators deciding what goes into a museum, not just members of someone who's worked as a public, I don't mean any disrespect to any of you, but public bureaucrats should not be making decisions on what buildings should be heritage listed. Thank you.
Thank you, Ms. Seidler. It's the chair speaking, Mr. Abrahams.
In our submission, we focus again on the number of technical disciplines that could be required and that they should be in the majority. Although I think we all have to recognise the Heritage Act is does have representation on its Heritage Council from stakeholders, and the National Trust play an extremely important role in that. There used to be more, they're the only one left. So I think stakeholders of the community are not a bad idea. And I think the Heritage Office should also have a formal role on the Heritage Council. At the moment, that's one of these relationships that I referred to that is just not defined. There are delegations, but they're fairly insignificant and they're not defined in the Act except the power to delegate. So there's the director of the Heritage Office who's sitting at the back of the room in Heritage Council meetings and might occasionally be asked her opinion or his opinion. That's just not enough of a relationship to have a robust system. And lastly, I'd like to say that since the Act was written in 1977, a whole lot of disciplines have become professionalised and have arisen and become mature. And so you could actually name a whole lot more disciplines. And the one that we would principally think would make a lot of sense is people with expertise in conservation plan writing. which is the fundamental discipline of heritage, and that's not on the shopping list at the moment.
So, Chair speaking, Mr. Buttigieg, do you have any other questions?
Just briefly, Chair, and what about your views on the, I guess, the relative weight of or burden of the problem here? Is it the way that the Act is worded? Are there deficiencies in the Act which are causing major problems, or is it largely a function of the administrative machinery and the way that the Act's implemented that's the issue?
Ms. Seidler, you've raised your hand, and I think Mr. Abrahams has also raised his hand. Ms. Seidler, firstly.
Okay, so Polly Seidler. Well, I do note in the preamble to the Heritage Act, it refers to conserve and adaptive reuse. Those mechanisms then are prejudicial against a building with its original use and still being used in its original use. I think the Heritage Act was written in an era where buildings with their original use were not concerned about heritage protection. And yet you're going to have buildings now, be they buildings like churches or commercial office buildings, getting heritage listing that just want to do what a normal building owner wants to do and do their necessary repairs and upgrades. So whether it's tweaking the legislation to reframe people to see heritage is not about turning something into a mini museum and treating it like a mini museum. Australia Square Tower is locally listed, heritage listed. It has been a successful office building since 1967, but it should not be trampled upon. I might also note Australia Square in 2011, the owners were willing to have it locally, state and federally listed. I got one of the major law firms to provide a unified approval mechanism, but the state, local and federal bureaucrats didn't want to work with each other. That is exactly the sort of thing that a building owner does not want to be lumbered with 3 tiers of approval just to do what normal upgrades buildings need. It should be a single mechanism. Yeah, and I do think I think heritage systems do assume, I'm only speaking about architectural heritage, but heritage systems just assume against the normal commercial use of buildings, leases. I can say as someone who manages a heritage asset and a lease, that it's to try to instruct your commercial lease lawyers to put all the relevant provisions in there to protect the heritage aspect, particularly tenants who are going to make good their, at the end of a lease, a tenant puts in their fit out and make good, just to safeguard that that'll be done correctly. There's just a lot of different things to keep in one's head at the same time, and not all owners are willing to engage with that process.
It's the Chair speaking. Thank you, Ms. Seidler. And I think Mr. Abrahams, you had raised your hand to respond to the question from Mr. Buttigieg.
Thank you. The question is about where is the effort to be laid in the legislation or in its implementation. Clearly, we would say the answer is both. As Polly's just described, there are truly legislative misfits with other legislation, such as the exempt and complying and the relationship between federal legislation and state legislation. Those things are legislative problems. I think it has to be recognised it's a very unusual act because it relates to planning and environmental legislation, yet at the core of the heritage legislation are cultural and social concerns, which is why I presume it's in front of this particular parliamentary committee. So that is not going to go away. That is not going to change. That's part of the magic of the Act. But it does mean that the Act has to be really diligently led. Otherwise, it's had periods of great flourishing, and it's had periods of decline. I think we've just come through a decline. I would evidence that by saying the Heritage Council, although one of its key obligations is to educate, hasn't made a publication for 11 years. And they've only recently started their social media. In the 11 years before that, they made over 100 publications, one of which is absolutely critical to every architect submitting a development application. That's the standard template for the heritage impact assessment, how to assess impact. And that document is more than 20 years old, and it's just completely out of date. So that's a problem of diligence. And lastly, I'd like to say that it is partly a practical problem, but it's also partly a perception problem, how heritage is seen. In the 70s, it was seen as quite a static thing. And what Polly is saying, I think, is a really good example of how heritage needs to be seen as something that's dynamic, that's related to people, and that it's the relationships between the building and its use and its artistic basis and so on. That's a dynamic and inclusive attitude can only do a good thing for heritage. So it's not a very straightforward answer, but I really like your question.
It's the chair speaking. Thank you, Mr. Abrahams. I'll now invite Reverend Nile and Mr. Shoebridge. Do you have any questions? Reverend Nile, if you could repeat the question, Reverend Nile, you're on mute.
Brad, you're still on mute.
You're still on mute, so I'll just go to Mr. Shoebridge. Oh, no.
I'm still here.
I think Reverend Nile's about to come off.
Well, I could kick it off with a question and we'll go to Fred.
If you could, Mr.
Abrahams, I see that you don't support the proposal for the fragmentation and additional categorizations proposed in the discussion paper. Do you want to explain why?
Many of the respondents to this have got the same answer. And some of them are going to be able to explain the reasons better than me, but it doesn't make sense procedurally. If something's important, it should be listed independent of what category it's in. Secondly, the 4 categories aren't the same, and to treat them differently is doesn't add any value. That I haven't got them in front of me, but I think the 4th category is locally significant items. Well, they're not listed anyway under the Heritage Act, so that's a non-category to start with. And there's a danger in the first one of the idea of something being listed because it's in an iconic category. For a start, there aren't many things that would be in an iconic category, and iconicness isn't a particularly useful heritage listing principle. So I guess some of the problems are intellectual and some of them are just practical.
Well, one of the rationales is that there would be a lower form of protection for example, residential properties. Now, your institute is contained in a residential property, which has, and residential properties can have such distinct differences in terms of their importance, and treating all residential properties as though they're uniform and of a lesser need for protection doesn't seem to be particularly well-founded in heritage assessment. And after you, Ms. Abrahams, I might ask Ms. Seidler what her views on that are.
Yeah, Polly Seidler. So, I speak. Yeah, so my mother lives in a heritage listed residence, state listed. I can just say and I've experienced how when Harry Seidler houses are being sold, realtors do not want to mention if the house is heritage listed. This is seen as a restriction and a burden. And I should have said before, procedurally, I just think there is a way to address that, particularly if it's on a local listing, not if it would have been otherwise complying development consent. If you can get somehow the heritage tick off without having to do a full DA with what would otherwise be complying development consent, that would help things, because then you're not constraining owners with a procedural burden. If a heritage approval can be given for what would otherwise be complying development consent. My mother, she's just, her roof needs replacing after 54 years. It's taking a very long time. I believe it's under process now, but while I would like Seidler things to be heritage listed, the good ones, I do understand owners' concern about that.
I suppose what I'm really interested in is focusing on the heritage protections under the Heritage Act, which is what this inquiry is about. And quite often we get discussions about, and I understand it, about the problems with heritage protections through planning instruments at a local level. But if we're talking about a residential property that should have state heritage protection under the Heritage Act, do you think there's a rationale, Ms. Seidler, for giving it different and lesser protections than other state heritage items simply because the nature of the property is a residential property?
No, because I mean, Polly Seidler, even more, no, I can't say it just for residences. I mean, what about commercial building owners? You might see behind me, I have Australia Square there. I have the Seidler office building there. These buildings were built with the intent of commercial leases, and most building owners want that flexibility to do, as I say, the repairs and necessarily upgrades. I'm not sure why a residence gets a separate status.
I might ask Mr. Abrams and then Mr. Beatty if they have any views on this. And don't limit it to just the residential categories, the concept of categorisation.
I think you can, I'm hearing from what Polly said very clearly that you soon get into category issues if you try to make one class of building enjoy a different level of or type of protection than another. Suddenly it moves you away from significance. If it's listed because it's significant or important somehow, as soon as you list it for another reason because it's in some category, or you change the way you deal with because of a category, then you've just undermined the basic criteria. So I just think it would be, and administratively it would be terrible. What if a house was listed, but then the house was in a listing category and some department over there was dealing with houses, and then the change of the house changed from being a house to a boarding house or to a museum or to a guest house or some other use, then it'd have to change categories on you. And that does happen quite a lot. So I think, well, I do have the opinion is that it was said by the chair of the Heritage Council that this might be a precursor to having a system where houses were only ever considered for what was on the outside and their interiors were never to be listed. But clearly that's not the case. There are many houses whose interiors are more than worthy of listing. So for many reasons, it has no support in any of the submissions that have been given to you.
Indeed, Mr. Abrams, the property that your organisation occupies has changed its use from a residence to the centre of your organisation. It's like a case in point for how categorisation doesn't really even follow adaptive reuse.
Yes, we have an opportunity to keep it simple. You list things on the basis of significance. That's simple and straightforward enough.
Mr. Beatty?
Thank you. Yes, we didn't comment on the categorisation in our submission. We commented more on the analysis of significance. What might be more valuable in the categories is the analysis of significance, which tells you what's significant about this item. And Mr. Abrams mentioned the interiors of some residences. Yes, residence by Mr. Seidler, or there were 3 houses that sold in the last 18 months by Bruce Rickard, another architect who designed right down to the last detail. And so the interiors there would be just as significant. So I think if the listing of an item is robust enough that it picks up all of the significance of it, that would be more useful.
Could I ask the three of you, and we might go again in that order, starting with Ms. Seidler. The government's discussion paper talks about 3 key policy themes that are guiding all of these changes, and they are making heritage easy, putting heritage to work, making heritage relevant. But a series of submissions, not least from the National Trust, point out that that doesn't include conserving and protecting heritage. Do you think the government's 3 guiding themes are adequate, or do you think we should be starting with conserving and protecting heritage?
What was it? So easy, relevant, and I'm sorry, what was the last?
Easy,
Yeah.
working, and relevant.
Well, okay, Polly Seidler, I do, as a property owner, I do like the sound of all of that, but not at the expense of undermining the heritage significance. I guess one thing related to this is I do see as I'm a little bit of an outside player to, shall I call, the heritage industry. I'm not talking about architects. My concern is that there are a lot of people who actually, they have no interest in making things easy because they're doing themselves out of a job. I know that might be controversial, but and that's when the government is tempted to then sort of put its brakes on heritage to, you know, declare something state significant development or the like. I think I've said, yeah. As a building owner, you do want it to be working. I mean, as a commercial building owner, I don't want to have to tell my tenants they have to get a DA when everyone else gets to do a complying development consent. It's just not. It's a commercial building. It was designed for tenants to come and go. This is just an unfair restriction and burden because I have a well-designed building that's worthy of heritage listing. It's penalising me in a way.
So do I understand, Ms. Seidler, they're not bad things to have. You'd support them if you can, but they can't undermine the core object of the Act.
Yes.
Thank you, Ms. Seidler. I might quickly ask Reverend Nile if he would like to
thank you,
raise
Mr.
this
Chairman.
question.
I've got 1 or 2 questions for Polly Seidler, based on her submission 86, where she raises some interesting questions that I haven't seen mentioned in any other submissions. The first one is in her submission. She raises the point that even though New South Wales heritage officers are willfully blind and ignore federal legislation when considering demolishing or altering an architect's building. I don't think we've had many discussions about state versus federal legislation. I think it's one of the first that I've seen. Would you like to comment on why the federal legislation doesn't seem to have any consideration? And what is the federal legislation?
Yeah, so basically since 21 December.
Question for
me, yes. Since 21 December 2000, artists, whether artists, sculptors, architects, have things called moral rights of artistic integrity and attribution. Now, it's a federal piece of legislation enacting an international covenant, which most other Western countries in the world have. It's not a quirk, but unfortunately, our heritage systems, everyone thinks, oh, it's real property, and everyone just thinks of planning law, and they're just not used to considering there is a federal piece of legislation relevant to whether you should be approving the change. Now, I've given an example of where someone has demolished a heritage listed, locally listed building, and then erected something else on it, put the name Harry Seidler, and that's false attribution. There's nothing to do with Harry Seidler on the site. And just the processes of the Heritage Office, they're not used to, I guess, dealing with heritage where the original creator or their estate still has relevant reputation, which lasts, again, I'm only talking architects who died 1955 or later. That will move to 1956 back in 2027, because it's life plus 70, the life of copyright. These rights were watered down quite a bit to protect the property industry, but my point is that people are not giving any moral rights notice, not engaging in good faith when they're authorising changes to a building. And I can tell you, someone who goes around changing a Harry Seidler building loses its distinctiveness of being Harry Seidler. And the solution is solved by, I think, a provision recognising, just asking the question, did the architect die before the end of 1954? Is the work still in copyright? And then at least people can consider the issue. I'm not talking about where the architect died 1954 or earlier. This federal legislation is irrelevant. But I do think whether the Act just needs to refer to it. Otherwise, heads up, one day some well-intentioned heritage officer or developer is going to get issued with a writ from the federal court for authorising infringement under federal law. And even though it's fully compliant with New South Wales law. I mean, the own Department of Planning just say, oh, if it's not heritage listed, go and demolish it. It ignores the separate question, well, did the architect die before the end of 1954 or not? In which case you have to go and give notice under the federal moral rights legislation, which I note the New South Wales government did before it demolished all the buildings on Martin Place. So someone at Macquarie Street has been well advised for its own work, but the heritage systems and officers, I'm like talking as if I'm from the moon when I even mention the issue of moral rights under federal law. I've come from a copyright law background, and it just staggers me that here are government officers operating as if this federal law, okay, it started December 2000, but it's been 20 years and they all operate as if they can ignore it. It's very difficult. And then the hypocrisy when they do go and alter a Harry Seidler building, they love using the name Harry Seidler, and yet it's something possibly that we disown ourselves from. You'd never do that to an Aboriginal person or an Indigenous person labelling something without consulting with them. So why are we doing it for modern creators worthy of heritage protection? I think it's a gap I think the Act could be amended by just saying for works which are still in copyright and where there are moral rights, this has to be I don't know, bureaucrats like checklists. Just put a little checklist button somehow in the legislation. Maybe that will help address the issue.
It's the chair speaking. Reverend Noel, did you have a quick one?
Thank you for your answers. Thank you for those answers. You've clarified my concerns. Thank you.
Thank you, Reverend Noel. Government members, any questions? And Mr. Franklin has a question.
Thank you very much, Chair. I'll just a couple of questions before I throw to my colleagues, to Mr. Abrahams, if I may. The first is around, if you could just give us some sense of some of the challenges that architects currently face when they're sensitively reusing state heritage items, and if there are opportunities to alleviate some of those challenges through the current system which aren't being utilised and aren't being taken up in the way that they could be. You're just on mute, Mr. Abrahams.
Thinking time.
No, I understand. Sorry.
There is a category of work where it's state significant development and the Heritage Act is switched off. So in that respect, there's an uncomplicated relationship. So a lot of the major asset recycling programs like the Lands Department are in that category. The Australian Museum, the Art Gallery, not that it's listed, but they're in that category. For projects that are in education sphere, that's also not a problem because the new state environmental planning policy for education also switches off the Heritage Act. Again, not that many schools are listed. For projects that are domestic, there are very few houses, relatively speaking, on the heritage list. They are numbered in their hundreds, not their thousands. Yes, it can get very complicated when you're trying to adaptively reuse a house, but that's an unusual scenario anyway. There are real difficulties where the place is a landscape or the place is a precinct because it involves that's going to be sophisticated territory anyway. So you've got to be ready for it to be complicated. I think they're the types of projects I mostly have experience of as a member of the Institute. But if I think of another one, I might want to have an auxiliary chance to answer your question. But to answer, perhaps to wrap an answer in with what Member Shoebridge asked about easiness, I think easiness is a desire we all have. In the environment, things are never completely easy, although we would like them to be. Sometimes we make decisions in the name of easiness and it makes it harder. So in our submission, we talk about the problems with exemptions created last year, which again makes some things easier, but makes some things harder at the same time. So there's really no substitute for wisdom on this one. Things just have to be wisely dealt with. And please remember, everyone, we're not talking about more than 3,000 heritage items. This is not a big category of parcels of land, but it is a very big category of what people care about. And it's curious that heritage does tend to be, therefore, because it's got a powerful act, it tends to be the battleground for all kinds of things. That's just an aside.
Thank you, Mr. Abrahams. From that, I think that there's obviously an overwhelming support for activation and adaptive reuse of state heritage items. I note in your submission, you say that a number of incentives already exist in the Act, but knowledge of them's poor. I was wondering if you could either or both identify those, or speak more to, I should say, those incentives which could be better promoted and taken up, or alternatively, what kind of incentives and programs could be introduced to support the activation and adaptive reuse of these items.
Thank you. The classic incentive of the last 40 years has been the grants program. And it's been run surprisingly consistently for 40 years. The amount of money handed out varies, but as a program, it's been very consistent under all governments. I think that has to be acknowledged. There are some incentives that in the Act to do with relief, land tax relief. There are some attempts to get a relationship with the federal cultural deposits legislation, so that money spent acquiring or working on a building could be a cultural deposit, as the same as me giving a painting of Captain Cook to the art gallery. I think that's an impressive thing that could be explored. There is a very, very significant incentive, not in the Heritage Act, but in the Environmental Planning and Assessment Act, Section 510, which is almost never used, but is a startlingly fertile source of support for heritage, the incentive clause under that Act. That unfortunately has no relationship to the Heritage Act, and it's unclear as to whether listing on the State Heritage List is a burden or a switch on or a switch off of 510 clause in the Environmental Planning and Assessment Act. Sorry for all the long titles.
No, that's excellent.
There are other incentive programs in Victoria, which is talked a lot, and many of the submissions refer to the Victorian one.
Indeed.
I think the best other really good incentive that has run well over many years is the Heritage Advisor System, free advice. It's again, that's actually not something set up by the Heritage Act. It's been set up by the Heritage Office about 25 years ago, and that free advice has really led to a lot of architects being able to access heritage, and their clients being able to access heritage advice and heritage consent advice, and that's very significant. But they're my answers today.
Thanks, Mr. Abrahams. I appreciate that. That's excellent, excellent information. I'll pass to my colleagues now.
Thank you, Mr. Franklin. Mr. Mallard, did you wish to raise a question? And then I'll go to Mr. Martin.
You can't come off mute.
Mr. Mallard, are you coming off mute? If not, I'll go to Mr. Martin.
Go to Mr. Martin.
Here he
I'm
is.
muted, but Mr. Martin's fine.
You sure? Okay. Thank you. I've got a question for EE architecture, and that is in relation specifically to the adaptive use that I believe your firm has worked on in relation to the Newcastle Council Admin Centre complex, which is still working its way through the state heritage listing process. Did you get any advice on the potential impact of state listing on that project and the benefits of adaptively reusing the building compared to if they were to use a different site for that process? For some in the community, you might or may not be aware that it's now being used as a 5-star hotel.
That's right. It's a long and involved story. Do you mind if I take it on notice so we can actually get it up on the sequential order? Because,
sure, that's a good idea. Fair enough. Thank you.
Terrific. Thank you so much. Thank you.
All right.
Shane?
Yeah.
Thank you, Mr. Mallard. Mr. Mallard, you're back.
Shane Mallard, yes. I'll bring it all home then. Thank you for your submissions and showing expertise this afternoon on this Zoom inquiry, and it's good to see you there as well, Polly. And my questions are directed to Polly. In your submission, you focus on an area which I'm very keen about and concerned about, which is the protection of modern architecture. We've had a big debate in Sydney in recent months, fueled by our treasurer, about the worth of keeping brutalist buildings, which I'm a big fan of, brutalism. We nearly lost a Sirius, it didn't get listed. So what's your view on that, and what measures should be taken to protect, identify and protect modernist buildings in our city?
Yeah, so Polly Seidler.
Includes your father's buildings, of course.
Yeah, okay, yeah. I might just say something that the brutalist basically means off-form concrete. And unfortunately, I think what's happening is that heritage is so focused on materials that even a whole classification of buildings get characterized by their material. And now, I don't know if you can see, but behind me, I do actually have a picture of our office building. There is some off-form concrete, and the home here in Kalara. Now, I actually out there, like I actually say, even though it's off-form concrete, my father distanced himself from this term brutalist because it's from the UK, and I think it's better that you look at the buildings not just as symptomatic of of the material, but whether it is a design worth protecting. I do know the Heritage Office looked at heritage listing, some of my father's buildings. They did a report, I think 2016, and the Institute of Architects spent a lot of time doing the draft listings back in 2018. Well, that's like almost 3 years later, and the Heritage Office, nothing happened. So for any building to be listed, someone has to do the hard research work, write the listing, and then it obviously has to get through the approval process. I have heard on the grapevine that someone has commissioned a report on some modern what are distinctive modern buildings going before the Heritage Office. But I think I perceive the issue is there's a lack of resources to read and process and consider listing those buildings. There's just, I don't know if there are many. My concern is there's not many people who have any background or studies in architecture history at the Heritage Office. I'm happy to be proved wrong, but I think a lot of people go into heritage because they've got maybe studied archaeology at an undergraduate degree, or they've done a general history degree. Whereas for architecture, you need people to know about design history and architecture history, not just because you've got people then who can't read drawings, they can't solve the problems, and they're not discerning what makes that building unique. Yeah.
But your view is from submission that there's a gap or a challenge or even a threat to modernist buildings at the moment because they're not being recognised for appropriate.
Because if they're not heritage listed, you can pull them down. Okay, yes, moral rights laws aside, people generally don't uphold that. But because if you're not going to list these modern buildings, what will happen is the owner will either demolish it or go and do such changes, which are complying development consent, and you go and ruin the building. You'll put a different facade on it. You'll infill what is might be a spatial cantilever. You'll change the spatial arrangement, and you've ruined it.
Well, the classic is the American Express Tower on George Street.
That's right. Yes.
Yeah.
Yes, that's right.
Or the Bajura Children's Court.
Well, indeed. If we've got time to finish up with one quick question, again to Polly.
That's a very quick one, Mr. Mallard.
Okay. Well, it's in the submission, but you did, and you talked about it a minute ago. So, and that is an interesting idea of complying development consent, complying development activities that you can do at a heritage building that's been ticked off by the Heritage Council. So, like your mother's roof, rather than having to go through the whole process. Do you want to just elaborate on that a bit more?
Well, like if my mother has a roof that needs to be repaired, if it weren't for heritage listing, she'd just get on and repair it. Now, she co-designed it. She's the award-winning architect. It's just, I want to have an exception that if the building is heritage listed and it's the architect making the submission, that you guys, that in itself be the imprimatur that it's okay to proceed. I can't see anything being achieved by bureaucrats approving the roof there. With the complying development consent, again, for a commercially listed office building, if I get the heritage tick off from the local council, don't make me do a full DA. I don't think anything's achieved with that, but anything locally listed basically takes it out of that certified jurisdiction. I'm all for basically getting the heritage aspect approved, but don't make me then have to do a full DA. It's longer, it's more time consuming, enable the heritage tick off with a CDC like in Victoria.
So this goes to our proposal to uncomplicate, to reduce the complication around managing heritage buildings. Okay, thank you very much. Thanks for your submission.
Thank you very much, Ms. Seidler and Mr. Mallard. On that basis, I'd like to thank Mr. Stephen Beattie, Mr. Hector Abrahams and Ms. Polly Seidler for attending this hearing and for your input and free-flowing participation. I note that Mr. Beattie has agreed to take a question on notice. The committee, Mr. Beattie, has resolved that answers to questions taken on notice be returned within 21 days. The Secretariat will contact you in relation to the questions you have taken on notice. Finally, I extend my appreciation to the committee members for their assistance and support during today's hearing. In addition, I would like to sincerely thank the Secretariat and the IT Service Desk for their professionalism in helping to facilitate this virtual hearing. Our fourth hearing is scheduled next Tuesday, the 24th of August. In the interim, I wish everyone a pleasant afternoon. Keep safe, and this concludes today's hearing.
Thanks, everyone.